Lordship, pardon my mention, Lordship, extremely urgent matter of surface act, Lordship. Tomorrow they'll take out possession of my entire residential, can take out tomorrow, Lordship, urgent matter.
And the
Up to which year it is, Lord?
2021.
It is there.
land acquisition rehabilitation.
Yes, but relating to area salary of the retired judicial.
This is a rehabilitation resettlement matter.
Give it.
So Lordship can take up.
Lordship, representation challenging the DRAT.
Please use the mic where you're not clear.
Lordship, challenging the DRAT order. Lordship.
Give it.
I beg your pardon, Lordship. Lordship, weekly list item 36. It's a matter challenging the Odisha Judicial Service preliminary examination. It is on the list, Lordship, but supplementary list is to be taken up first, so it might not reach. I pray it may be taken up as the last
Let's
item.
see that, yes.
My lord, it is land acquisition matter.
Challenging the selection of Odisha Judicial Service.
Give it.
Supplemental list item number 1.
Sorry to see, Lordship, in fact, that matter 2013.
I don't think.
No, but if file is misplaced, Lordship, permit, then I can take my copy on that. Then I can
First of
execute.
all, there are so many defects
Lordship.
on one thing, and the second is that the order which you are challenging.
That's true, Lordship. That's there, but I don't have also file, Lordship.
There are
Sir,
4 or 5
Lordship only say no instruction if cause of action, then I will, Lordship.
Mr. Shukant Kumar Dalai, Learned Counsel, appearing for the petitioner, submits that he has no instruction in the matter. And he may be permitted to file a fresh writ petition if the cause of action still survives. And in view of such submission made by the Learned Counsel for the petitioner, the writ petition is disposed of. Yes. Next.
Grateful, Lordship.
Item 2.
Item 2, Lordship, proceeding is going on. So possession da de the Lordship.
Process is on.
Lordship.
The proceeding is on.
Lordship going on. Say causing 10 days with the possession da certificate.
That is right.
2 weeks after, Lordship.
Because they are going in the process.
Lordship. 2 weeks after, Lordship.
Why unnecessarily this matter will be kept pending?
In case any fresh cause of action arise, you come. Otherwise, there is
No.
it is going on in the right process.
Lordship, they do to.
There is nothing illegality in it. You are getting the order.
Petitioner seeks for an adjournment for 2 weeks.
Lordship.
Put up this matter in the week commencing from 20th August 2020.
Lordship. Deeply possible.
Item 3.
May I please, my lords?
But annexure 24, page 55, that is the order dated 5th June 2024 passed by the Learned Tribunal, rejecting the claim of the petitioners for appointment under compass ground mail. May I pray, my lord? Lordship, kindly give us the original order of rejection mail, that is annexure 4 mail.
Have you gone through the decision of this court in Jemarani Maji,
No, my lord.
passed in 2023? Kindly go through it. I think that will be better. It will ease our case. Reason being the entire issue that has been raised here, questioning the disability of the person, number 1. Number 2, the application of the old rule, new rule, all these things have been taken together. Along with the decision in the matter of Malay Anand versus State of Orissa.
In this case, my lord, the candidature of petition number 2 rejected,
Yes,
only having
hypertension.
hypertension.
Yes, that has been dealt with. Whether
Go
it can be
through,
done,
go through those 2 days.
Yes, ma'am.
We can take up
we
this
can take
matter
up this matter.
next week. Okay.
Half of your problem will be over. We can simply pass an order. There is nothing left. Please go through whether it
1 week after that.
applies to it.
The Land and Council for the petitioner seeks for an adjournment for 2 weeks to go through the ratio laid down by this court in the case of Sahoo Hon'Ble. Yes. Is this matter be commencing from 20th of August 2024?
Item number 4,
Yeah, I please. Annex 3 is pending before the OP number 3, the page number 29.
Okay. Annexure 3 is the representation pending before OP number 3. 3 months time granted, okay, from the date of production of the certified copy and order to be communicated. We have expressed no opinion on the merits of the representation submitted. No? Okay.
item number 5,
5 and 6.
Same,
Same,
Same, all right.
6.
item number 7,
Lordship, item number 7, I am appearing virtually in this matter, Your Lordship. Lordship, I am challenging this writ petition has been filed challenging my acquisition of my land under the Subarnarekha irrigation project. I have submitted one representation on 5th of November 2022 by Annexure 3, Your Lordship.
Okay. What is the date you said?
5/11/20.
Lordship, 5/11/2022.
Annexure
Annexure
3 is
3.
the representation submitted on so and so. 3 months time granted for disposal and order to be communicated. Yes.
Deeply obliged, Your Lordship.
item number 8,
Wait, please, Your Lordship. The petitioner in this case, it is simple case. That is that application is made for granting of lease of land, and the Tahsildar Sambalpur has not yet considered the matter.
Have you made any representations?
Here, the lease application was made, and verbally the petitioner had been to the Tahsildar.
Right.
The application, Mr. Counsel, the application for lease that was made on 7/2/2011, which appears, and in the meantime, more than 13 years have passed. So what is the status of that lease application? Have you sought for any instruction to the RTI or something else to know that what is the...
No, my lord. But simply has approached the Tahsildar, as well as the collector verbally.
Have you sent any kind of that has been already told that representation or
No, my lord.
they are made?
No, my lord.
We do not know whether this application is still pending or not.
It is pending, my lord. Direction will be given to consider the case.
Lekhantu, it is submitted by the Land and Council for the petitioner that the petitioner has submitted an application for lease of government land on 7/2/2021, 7/2/2011, before the opposite party number 3, Tahsildar Sadar Sambalpur, with a prayer for grant of a piece of government land appertaining to so on. So that is in the paragraph number 6. But there is no progress in adjudication of the application for lease, and direction may be issued to the concerned authority to expedite the disposal of the application. The Land Council for the state submitted that he is having no information regarding whether the application is pending or disposed of. Considering the submission made by the Land Council for the respective parties, without expressing any opinion on the merits of the application for lease by Danesh Chettu. It is directed that if any such application is still sub judice, the so and so opposite party number so shall consider the same within 3 months from this one, and in accordance with law, and communicate the order to this one. So, okay. Yes, dispute.
Item 9.
Yeah, if it is not been disposed of in
Not similar,
that word may be added. Okay.
My lord, similar matter is there, my lord. The connecting matter is WPC 28860 of 24. That's it. 2 weeks after.
Yeah, it is to come with WPC
WPC 28860
28860 of 2024.
24.
So that matter, when you filed this is 2024 means it is a fresh matter.
Lordship.
Okay. Just a minute.
That is an item number, this one,
9, Lordship.
in this board.
Lordship.
The earlier one,
Yes,
no.
Lordship.
Item number?
So item number 9, Lordship.
9.
Yes,
No,
Lordship.
this item number. The present one, the one that you are referring to. Has it
Mr.
come up the-
Counsel, this WPC number 17305 of 2024, C.DASH versus State of
Lordship.
Orissa. It was filed on 22/7/2024. Do you mean
Lordship.
to say that within the span of 1 week and another writ application has been filed, which is number as 28860?
Lordship.
So 11,000 writ applications have been filed within a week. Are you following what we are?
Lordship.
Either the
1674.
case number is wrong.
Lordship, diary number said actually.
Huh?
Should diary number?
Diary number you said.
Sorry, Lordship.
Oh.
16743
This is number is 28860.
is diary number.
You remove the defect, then that
No,
will be.
already removed, Lordship.
All right.
Uh,
The learned counsel for the petitioner submits that another connected matter is pending before this court, which is number as WPC D na diary coaching the diary number which is 28860 of 2024. देखी देवे सर diary number would list में, and the defects have already been removed,
Lordship.
and the matter may be taken off after 2 weeks. Okay, put up this matter in the week commencing from 20th August 2024 with so and so if the defect is already removed. Yeah.
Item number 10.
Weekly list item 6 same.
Item number 10, 8 पर गल.
No. Weekly item 6 yesterday man passed on same.
Oh, yesterday. That was all.
हाँ गतकाली रो जो item number कितने में?
6,
6,
7, 10, 11.
6, 7. How you see ये
Only one item kindly 6.
अच्छा 6 संगरे एक बार दियो. Item number data yesterday item number 6 संगे है ना जहाँ order is.
Not only the OA number and date.
Obviously.
Item number 11.
Sir, approach is Honorable Court challenging the order passed by the Central Administrative Tribunal Cuttack Bench Cuttack in way number 157 2018. That is Annexure 8. In this case, petitioner's claim is to grant him notional promotion as has been granted to the other juvenile placed person who are selected, who are scored less mark and has placed below to him. They have been granted notional promotion, my lord. Your lordship will find Annexure 2, your lordship find page 15.
No, who is for the opposite party? Have you served a copy on the?
To the Central Government Council.
No. Have you given an extra copy? It is to be given to the Central Government Council. Have you given a copy to the Central Government Council? Anyone or Mr. Parhi?
I will.
My lord, item number,
Item
11.
number is 11.
I have not received copy, my lord.
That is exactly we are telling you.
I'm
Serve a copy, it can come next week, okay? The Land and Council for the petitioner seeks for an adjournment till next week to sub a copy of the writ petition on the Land and Central Government Council. Put up this matter, Louis commencing from 5th of August 2024. Okay?
Item number 12.
May I please? I'm challenging the order of dismissal passed by the London Tribunal dated 4th of January 2024, my lord, page 69, my lord. The London Tribunal was pleased to dismiss the original application only on the ground of delay, my lord. My case before my lord is that admittedly there was delay in preferring the appeal to the appellate authority, my lord. That's why, my lord, along with the appeal, the petitioner submitted an application under Rule 20 seeking condonation of delay, my lord. As no action was taken, he submitted a reminder. Thereafter, after the London Tribunal, my lord, Tribunal was pleased to dispose of the original application, keeping open the point of limitation to be decided by the appellate authority. And in compliance with the order of the London Tribunal, my lord, the appellate authority was pleased to dispose of the appeal on merit, my lord, appealing the order passed by the disciplinary authority and advised for filing revision. My lord, against that revision filed, the revision authority was pleased to dispose of the revision by order dated 27/4/2016 and
Oh,
within
it's
2 months, my lord.
on the ground of delay,
Fine.
your original application has been dismissed. Which are the relevant paragraphs you said? And have you prepared a date chart that when your you were that this is the period
Period of
for
delay.
which you are remained absent? What is the prepare a brief chart where you
My
not
lord,
preparing?
along with the repeats, I have filed a date chart.
Okay,
Senior
let us
case and
see
date.
that date chart. Okay.
My lord,
What is your period of absence from duty? That was the charge which has been so you were ill on 2/6/2008.
my lord.
Then
After 3 years.
after 3 years you joined the duty.
My lord.
Almost 3 years.
Right.
Then charges were served, article of charges in 2011.
My lord.
Then when the decision was taken, that is in 2013.
7 to 13, my lord.
7 to 13, no, 7 to 13 you were issued with a notice. And ultimately on 4/3/2013, the punishment was imposed and you were removed from service, right? So then you preferred an appeal in 2015
15.
to OP number 3
Right.
with an application for condonation of delay, right? Then what happened to that
My lord,
appeal?
appeal was not disposed of, so I filed a reminder, annex of 9, page 33, my lord.
Okay, then you approach the,
Then I approached London Tribunal, my lord.
okay,
Annex of 10, my lord.
there was a direction to dispose of the appeal.
My lord.
Then,
In compliance to the order of London Tribunal, the appellate authority was pleased to dispose of the appeal by order dated 7/1/16, annex of 13, my lord. My appeal was
just
disposed-
appeal was disposed of on
merit, my lord.
7/1/16.
7/1/2016.
16, my lord.
Then,
And the appellate authority advised me to prepare, if I can
Agreed.
prepare an appeal, a revision, my lord, that is second appeal. So revision file, revision petition is under annex of 14, page
it's all right, but
41.
then what happened?
The revision authority was pleased to dispose of the revision by order dated 27/4/2016, my lord.
Okay,
And the original application filed within 2 months, my lord. In the year 2000, there are within 2 months from the date of receipt of the revision order, my lord.
challenging the revisional law.
My lord.
Okay.
So that is as per section 21 of the 80 Act, the limit.
Now let us see that you said that it is on the ground of delay
Mine.
that Where is the relevant paragraphs in the order passed by the Lenin Tribunal?
Operative portion is page 90 to running page 24 of the imprint order, my lord.
24.
Page 92 of my
Internal
petition.
page 24 and running page.
92, ma'am.
No, that is also the conclusion part. Just about the discussion why reasoning he has been given.
May I pray, my lord?
It,
The person may kindly give 76 page, my lord.
page 76.
My lord.
Yes. 7.1.
7.1.
Please read it.
However, after lapse of 2 years, 6 months, he submitted appeal on 28/6/15 and filed way number so and so for this tribunal along with MA number so and so to condemn the delay in preparing the way billeted. Thus, the said way was not at all maintained will being suffered from delay and lapses. First of, however, this tribunal at the administrative stage without expressing any opinion on the merit of the matter or on the point of delay, dispose of way number so and so, directing the appellate authority to consider and dispose of the appeal.
Because by that time appeal was pending.
Mine.
Yeah.
Said
Then?
appeal rejected with a reason order, mine. It is considered that disposal of appeal by the order of this tribunal cannot give a rise a fresh cause of action and therefore this way is liable to be dismissed being suffered from delay and lapses. Since limitation has to be applied with all its rigors even if has affect a party. In this regard, he has placed reliance on the decision of Honorable Appellate Court in case of so and so, and I rely upon so many judgments on tribunal comes to a conclusion that my way is barred by limitation.
Okay. Then
Against
we have
that, my lord, I
come to
prefer-
paragraph number 9. Page number 79, internal page is 11.
My lord.
Please read it, paragraph 9.
From the record, it is seen that on 12 February 2020, while the proceeding was going on before this tribunal, the respondents have contested and objected the very maintainability of this way on the ground of delay and lapses, especially in absence of any application to condone the delay. When counsel for the applicant submitted that the delay in filing the present way had already been condoned in the first round of litigation and has prayed for adjudication of the matter on merit. The respondents in their counter also, in course of hearing, has again questioned the very maintainability of this way on the ground of delay and lapses and submitted that the said points should be decided at the first issue. In the said premises, while giving consideration to the merit of the matter, we have also heard on the point of delay and lapses / limitation.
Leave paragraph number 10 and come to paragraph number 11. Page number 80, internal page is 12. Paragraph 11.
From the fact and record, it is loud and clear that against the order of punishment dated 7/2/13, applicant prefer an appeal on and a reminder on 4/8/15. Thereafter, alleging non-consideration of appeal, he filed O number 817 of 15 before this tribunal, along with MA number 852 of 15, praying to condone the delay. This tribunal at the stage of admission without expressing any opinion on merit, as also on the application for condonation of delay, dispose of the way by the order dated 20th November 2015 with direction to appellate authority to consider and dispose of the appeal. Since the order of punishment was dated 7/2/13 and OI was filed in 15, submission of appeal militarily ought not to have a ground to condone the delay. We have gone through the earlier order dated 20th/11/2015 in one so and so, which was disposed of at the stage of admission without expressing any merit on the merit of the matter by directing the appellate authority to consider and dispose of the appeal by the applicant. Now, so the direction / order was passed by this tribunal, condoning the delay in preferring way at the relevant point of time. Thus, the said point remain unanswered and Therefore, the respondents have rightly taken sustenance in the present my lord.
Hmm. So delay has been condoned by the
Appellate authority, my lord.
by the appellate authority. That was not challenged by them.
No, my lord.
So it is not your fault at that point of time.
My lord.
You preferred an appeal, which is statutory appeal, and also filed an application for condonation of delay. The appellate authority condoned the delay, and there was no challenge, and
Right.
then the appeal was disposed of on merit.
Merit.
Then you file a
Revision.
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 Thereafter, revision application was disposed of, as you have mentioned in your date chart, that was on 27/4/2016, and you filed the OA within 2 months, right? So what should you have served a copy?
My
in
lord,
the-
I have served a copy.
So that is the only ground on which your application
My
has
lord,
been,
only
OA
the-
application
so
has been.
Though I have filed a review saying that delay
that-
condoned, but my review also dismissed.
No, that review will not be there, but
my-
naming once directly.
So let us. Issue notice, Mr. Who is the?
My lord, I am appearing. DSJ along with me, my lord.
Asha. Not a lucky. The
My lord, I will give sleep in this court, my lord, today.
okay. No, the name of also the Mr. Solicitor General, Deputy Solicitor General is to also be mentioned. Okay,
Yes.
both names you mentioned. The writ petition has been filed by the petitioner Ranjan Kumar Gedi, challenging the orders dated 4/1/2024 and 9/1/2024 passed by the Land Central Administrative Tribunal Cuttack Bench in OA number 345 of 2016 and RA number 2 of 2024 under Annexure 20 and 21 respectively. The with a further prayer for a direction to reinstate the petitioner in service with all consequential and financial benefits. Placing the impugned order under Annexure 20, the Land and Council for the petitioner submitted that the original application was dismissed by the Land and Tribunal mainly on the ground of delay. However, placing the date chart, he submitted that there was no laches on the part of the petitioner in approaching the tribunal. In fact, after the revision was disposed of by the opposite party number 2 under Annexure 16 on 27/4/2016. In June 2016, the original application was filed before the tribunal. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. You are accepting the notice on behalf of all the opposite parties.
Yes, sir.
All right. He is taking over there. The London Central Government Council accepts notice on behalf of all the opposite parties. Let 4 copies of the writ petitions be served on the Land Central Government Council within a week. Matter to be listed, give a date. Object counter, if any, to the writ petition be filed in the meantime. Yes. 4 weeks. for a
Oblige.
date. Okay. Yes.
Item number 13.
May it please your lordship, my lord. I am Hishyat Puri, my lord. Here, the impugned order passed by the Central Administrative Tribunal Kotak Bench Kotak and Annexure 8 is also challenged because the humble petitioner's husband was working as a Khalasi helper under the Railway Authority and Annexure 1 met tragic death, that is on 15/4/2010. However, he was not granted pension till his death due to non-availability of the records minor. As a result of which, the humble petitioner, the wife of the deceased my lord, approached the Central Administrative Tribunal, and Central Administrative Tribunal made Annexure 8 running page 27 only dispose of the repension pending before the authority concerned. But till today, my lord, said repension has not been disposed of, nor also family pension has been given to the present petitioner, my lord.
No, you are challenging the order dated, what is the order dated?
5/4/17, my lord.
So 5/4/2017 order, you are
My lord.
challenging 2024.
Because, my lord, so far the order is concerned, the order was passed that the repension, pending repension should be disposed of by the authority concerned. But
No,
till
please come to the operative part of that order, which has been passed by the London Tribunal. And as you said, it was dated 5/4/2017, right?
my lord,
Please come to that operative portion of that order.
my lord, that is
Paragraph number 4, just come to paragraph number 4. It is at page maybe
26, my lord.
26.
My lord, on hearing London counsel for the both sides and on perusing the records, I find that the husband of the applicant in his lifetime made certain representation to the authority making a claim for sanction of pension for the period of casual service that he rendered for the authorities. It is also, of course, a fact that the applicant has not produced any document in favor of the fact that her husband was ever regularized in service or temporary status was given to her husband during his period of service. But it appears that the again ground in the main ground on which the authorities did not consider the representation of the applicant is that no records with regard to his casual period of service was available in the office under which her husband was working, while any view on the merit of the way cannot be taken in at this stage. However, I am inclined to pass an order to the concerned authority to make a further search for the service records of the applicant's husband, so that if at all any admissible pension benefit are to be confirmed according to the rules, the same should not be ignored, causing financial detriment to the family of the deceased railway employee. Therefore, at the stage of admission, without going into the merit of the matter, I am direct to respondent number 3, to whom the requisition dated 21/13 has been addressed to make a further search and verification of the records, consider the same and pass appropriate order in a speaking and reasonable manner to be conveyed to the applicant within a period of 60 days from this receipt of the copy of this order. Since I am not issuing any notice in this matter, I am not giving into the question of limitation in filing of the OMI.
What made you not to approach the tribunal again on merit?
No, my lord.
Then
No, sir.
then how can you switch to this court?
Because, my lord, my pension has not been disposed of by the railway authority. That is great drawback. And my husband's service record till today has not traced out, my lord. That is also another drawback.
This is also not a final order that way.
The direction that
Ah.
was given that your representation is to be disposed of within a particular time period, right?
Right.
If the authority has not disposed of the same, whether you are to approach the tribunal once again by filing an interim application for the relief short for, or you are to approach this court on that.
It is my duty to approach again tribunal, my lord.
Yeah.
It is my duty to approach again tribunal, my lord.
So no communication if you have received, then you could have approached again interim application. We are not here to advise you what is to be done. So why
So matter may be again remitted back to the central tribunal, my lord.
you withdraw and approach this tribunal? Why for everything will pass the order?
After
Because
There was
there is
and,
there is a prolonged delay, my lord. That's why I pray, my lord. There is a delay, my lord. That's why I pray, my lord.
no.
It is pension matter, that is a delay, my lord. That's why I pray, my lord.
all right, it is because of you. When the time limit was fixed that within 60 days it is to be done, and that too in the year 2017, you slept over for 7 years, and then you, without approaching the tribunal, you have rushed to this court, come to this court after 7 years.
Petition is little
You
lady, my lord.
yourself say that no, the remedy lies with the tribunal. Approach the tribunal that such an order was passed in 2017 and we are in 2024. So the tribunal can seek for instruction to the appropriate council or the authority that about the status of the representation submitted by you and why this court would entertain such an application.
My lord, petition is little lady, my lord, and he did not approve the tribunal again in time, my lord. I pray.
We are asking you that on that ground you are withdrawing this.
My lord, my lord. I undertake to withdraw I pray to withdraw my lord. With liberty, my lord.
Filed by petitioner Susama Maji. For quashing annexure 7, which is the order passed by so for such and so, and with a further direction to the opposite party for disbursement of family pension in without any delay from the date of eligibility. It appears that the petitioner approached the Central Administrative Tribunal Cuttack Bench Cuttack in what is the number of that application?
That is my lord. 260 by
Plate number 260/1000/2016,
16, my lord, 16.
Okay. Which was disposed of on 5/4/2017 with the following direction. A paragraph 4 ru jo observation se karichanti seta quote kar debe. The Learned Counsel for the petitioner submitted that in spite of the order dated 5/2017 passed by the Central Administrative Tribunal, the authority, that is respondent number 3, has not passed any order in disposing of the representation dated 21/6/2013 and not communicated the order within the prescribed period. Even though the order was even though the order was not complied with, instead of approaching the Central Administrative Tribunal, the petitioner has filed this writ petition after 7 years. The Land Council for the petitioner at this stage seeks permission of this court for withdrawal of the writ petition to approach the Central Administrative Tribunal, filing appropriate application. In view of such submission, the writ petition is disposed of as withdrawn. Yes.
Item number 13.
Yes, Mr. Swine.
This is a matter regarding sexual harassment caused by the opposite party, Devashish Ghosh, a railway servant. On the basis of the complaint submitted before the Visakhapatnam committee inquiry is conducted, and ultimately it is found that he has committed the
Harassment.
and ultimately major punishment was awarded. That major punishment was challenged before the Central Administrative Tribunal, and that was upheld that this correctly punishment has been awarded. Challenging that, so Devashish goes to the opposite party, challenged before filing a writ application before this honorable court. But that order was reversed on the ground that the judgment was delivered 21 days delay, making 21 days delay. Therefore, the Honorable High Court remanded the matter for fresh hearing of the matter and passed a rescind order. Actually, matter was remanded. After remand, the judgment has been completely reversed and he has been acquitted, and order has been passed to give him all financial benefit and everything. And the earlier order was a very well-written order, that is Annexure 8. And the subsequent order is a very lengthy order, more than 50 pages, and citing some decisions which are not relevant for the purpose of this case, that has been considered and no judgment has been passed. The initial order is at page 290, Annexure 5. There is very well-written judgment. The relevant portion, if I will place, also kindly turn to page 179, paragraph 11. The pleadings as well as during argument, the counsel for the applicant has argued that the punishment imposed on the applicant is not one of the major penalties provided in.
What is the page number?
179.
No, 303.
Hmm?
303.
Internal page 179.
Page number is 290, it starts from 290. Relevant portion is at 303. 303, running page 303.
Yes, sir.
303.
Yeah. 303.
Again.
Oh.
Paragraph 11.
Yes.
Yes. In the pleadings as well as during argument, the learned counsel for the applicant has argued that the punishment imposed on the applicant is not one of the major penalties provided in the Railway Servants Disciplinary and Appeal Rules 1960. Rule 6 of the above mentioned rules gives a list of major and minor and major penalties. Proviso under Rule 6.6 for major penalties reads as follows: reduction to a lower time scale of pay, grade, post, or service with or without further directions regarding condition of restoration to the grade or post of service from which the railway servant was reduced, and his seniority and pay on such restoration to that grade, post or service. In the case of the applicant, the penalty recommended by UPSC and imposed by the President on the applicant is reduction to the next lower grade, with the pay being fixed at the bottom of this grade on a permanent basis. Rule 6.6 mentions reduction to a lower time scale of pay, grade, post, or service as a major penalty, with or without further directions regarding condition of restoration to the grade. Either restoration haba no haba, but in the case permanent basis to the grade or post from which the railway servant is reduced. In the present case, the punishment imposed on the applicant is pay being fixed at the bottom of this grade on a permanent basis. The expression on permanent basis certainly comes within the provision, with or without further direction regarding condition on restoration. Under Rule 6.6 of RS and DA Rules 1968, permanent basis denotes a time frame to extend the applicant's entire period of remaining service, and therefore there is no further need or direction regarding condition on restoration. During the course of argument, the learned counsel for the applicant cited the decision of the Honorable Supreme Court that is reported in 2012 Supreme Court 2840, in which it has been held by the Honorable Supreme Court that the order of punishment imposed being outside the purview of statutory rules is a nullity and cannot be imposed against the applicant. Punishment not imposed under the rules as a result of disciplinary proceedings cannot be awarded. Applicant's reliance on the decision of the Honorable Supreme Court in Vijay Singh's case is not applicable, since the punishment imposed is already prescribed under the rules. Similarly, learned counsel for the applicant cited the judgment of 1969 Supreme Court, page 983, to argue that due opportunity should have been provided to the applicant to defend himself in inquiry. Learned counsel for the applicant has also placed reliance on the decision that is reported in 2014 Supreme Court 2541, in which it has been held that non-supply of advice of UPSC and acting on the same amounts to violation of principle of natural justice. Relying on the decision of the Honorable so-and-so, learned counsel for the applicant contains that although complaints may be treated as charges, no formal charge was framed against the applicant and no further imputation of charge or documents was supplied to him. However, a perusal of the records and discussion in the preceding paragraphs shows that due procedure as prescribed under rules has been followed at all stages of disciplinary proceedings, and therefore the case law relied upon by the applicant counsel are not applicable in this case. In view of the above discussions, it is quite clear that in the present case, applicant's argument cannot stand in the scrutiny of law. The grounds on which OA is based are not sustainable. The case law cited by the applicant are not applicable in the present case, since the due procedure has been followed as laid down in Visakha case. The applicant has been given all reasonable opportunity to defend himself. The UPSC advice has been given to him along with a copy of the order as laid down by the rules. And finally, the punishment imposed on the applicant is well within the framework of rules. In view of the above, we find no merit in the OA filed by the applicant. It is accordingly dismissed as devoid of merit and all essential.
So why this court remanded the matter
This
again?
court remanded because this judgment was passed, judgment was reserved. After 21 days, judgment was delivered. The administrative tribunal rule says within 21 days, judgment is to be passed.
Okay.
Therefore, the remand order is there in the next page. The order is there, next page, 307 page. I'm reading it.
Annexure 6.
Yes, next page. That
Para 4.
Para 7, the relevant is Para 7. In view of the above, this court finds that admittedly the tribunal heard the matter and reserved the same on 2/1/2018 and pronounced the judgment on 16/2/2018. That is to say, beyond the time limit prescribed under Rule 105B of the CAT Rules of Practice 1993, wherein it has been specifically prescribed that order shall be pronounced within 3 weeks from the date of result. This question is no more res integra in view of the judgment passed by this court in case of Nityananda Barik versus Union of India. This was answered. Therefore, since this non-compliance of the provision contained in Rule 105B of the CAT Rules of Practice 1993 in delivering the order dated 16/2/2018 in OA number 903 of 2012 under answer 14, the same cannot be sustained in the eye of law and is liable to be quashed and hereby quashed. The matter is remitted back to the Central Administrative Tribunal Court of Bench for its fresh disposal by giving opportunity of hearing to all parties. It is made clear that this court has not expressed any opinion on the merits of the case.
Here, how many days after that reserve the order was passed?
Present case.
No, no, जोटाको आपण चैलेंज करथिले 21 डेज तो ये हबो कितने दिन में पास कल एक्चुअली ऑर्डर टा
more than 3 weeks हेगला डिमांड करो
more than 3 weeks.
more than 21.
There is no other provision. Suppose why we say so, let us say presiding officer falls ill or something like that.
He could not the reasons.
That is what.
No
So
reason,
by assigning reason, it can be extended.
That is
So
to
no
be
reason was
that
there.
is to be mentioned in the judgment,
mentioned in the judgment.
or it has to be again listed and then another date is to be fixed. The
Rule
process-
says so. That
That
is
I will
assigned
have
in the judgment.
Just let us see that.
105B.
Let us see that. 105 of the CAT rules.
CAT rules.
Have you CAT rules of practice 1993?
105B.
So for many reasons, suppose the time is so like
bona fide reasons for
maybe
there.
there is a bereavement in the family,
Yes, yes.
somebody falls ill, he himself falls ill, so he could not prepare in time, and
No.
thereafter he has passed a reasoned judgment. Can that be a ground?
Unless it is an inordinate delay. It's
yes.
just a day.
Bona fide delay must have been there.
Rule 105.
105B.
So date can be changed
To
with
notice to the parties.
With notice.
To the parties.
Yes.
The corporate phone out there, that means the matter has to be listed one second. Matter has to be listed and it has to another date. Mr. Swine, so what we understand from this 105 rule
Yes.
that suppose today the presiding officer reserves the order and then he has to give that when that order is to be pronounced and that cannot be beyond 21 days. So let us say that he fixed the date to 12th, right? So for some reason he could not prepare the judgment, he failed, whatever it may be. So if he could not deliver the order on 12th, either prior to that, if he says that no, I cannot prepare the order, or let us say immediately after that, he then the matter is again to be listed. And
intimation to
the parties are to be informed and that judgment could not be prepared and then another date is to be fixed. That is the
crux.
It speaks about the date so fixed. Date so fixed shall not be changed without due notice to all parties.
To all parties.
Then every we pass the order, the judgment is reserved, the order is reserved. So, but there you cannot pass a order like that. You have to fix that on such and such date.
Either fix the date or pass the judgment within 21 days.
Yes.
After 21 days, if an order is passed, then parties to be implemented and thereafter order is to be passed.
No, when the orders are reserved, the date for pronouncement shall be fixed.
Yes.
So that means in every order, when you are reserving the date is to be fixed for the pronouncement of the and the date so fixed shall be. That means you cannot say that an order cannot be passed that the order after hearing the party the order is reserved or the judgment is reserved. It cannot be passed like that. You have to fix a date for pronouncement of the judgment or the order. but that should not be beyond 3 weeks.
Yes, yes.
Then if any problem arises, any for which this could not be possible, then if it is to be again brought to the board and intimated the parties, another
The
date is.
function of the party may be extended.
So in this case, on that ground, it was
was
remanded back.
Remanded back.
Then it was reheard.
It was real.
Then what further order was passed?
Further was annexure 1, completely changing the order previous
That
order.
is the whole thing. It is the pronouncement of judgment is delayed.
Yes.
All right. It was not within the time.
Within
Is
time.
it required that the parties are to be again reheard?
The Honorable Court has directed.
Or that is a direction.
That is the direction.
Otherwise, it's
Otherwise, not necessary because he has already heard.
because every time if there is a delay, we will be rehearing a matter. And new fact may come again.
Because the order was that it is to be a fresh disposal by giving opportunity of hearing to all the parties. So the presiding officer might have changed in the
Very
meantime.
long delay in the High Court.
Okay, so when the after remand,
Yes.
the hearing was made and the order was passed by the annexure
1,
1.
page 58.
Okay,
That is 7/12/2023.
okay. So the Mr. Swami, what we say that it is after all a question of how a particular presiding officer appreciates the matter.
Appreciated.
So merely because X has passed an order on the available material on record, it does not mean that Y is to stick
No,
to it.
it doesn't.
So because the fresh opportunity has been provided, so he will hear it afresh
Yeah.
and obviously apply his mind. So he has, so on that ground,
Yeah.
can it be a matter that on that ground itself, merely because
No,
X has passed the order like this, Y has changed the order, so that is not a ground. You have to
No,
show.
what I am submitting, that order has been changed without any proper reason. That reason assigned
The
subsequently.
the reason which has
is
been
not accepted.
assigned
Yes.
under the impugned judgment or order, that is
That
not,
is to be, yes.
that is to be, it's not that it cannot be ground that merely because the order was changed,
No.
that cannot be a ground. entered.
That I don't say.
Yeah,
What I want to submit,
yeah.
that the earlier everything has been taken into consideration,
Mm.
and those things are not taken into consideration properly by the latter stage after review.
No, again, it question is that you see the self same of facts,
Same set.
one judge, if it is heard by 2 judges, we can say that
View
one may entertain it, a writ petition and pass a order which allow the writ petition. Other judge may dismiss it. It depends upon the how he look into the matter and appreciate the matter.
Yes.
So that cannot be a ground
No,
unless
sole
you
ground.
point out that there is anything perverse in the order which is under challenge. So what is that perversity in the?
Perversity is here they say that UPSC's views is to be given to the applicant.
Come to that portion of the order where regions has been assigned
Yes. Yes.
and the relief has which has been sought
Yes,
for
yes.
has been granted.
You also can page 82. Page 83. Paragraph 6.
Yeah.
Yes. We have considered the rival submissions of the parties and perused the records. We find that instant OA was entertained by the order dated 12/12/2012 and opportunity to file a reply within 4 weeks was granted to the respondent. Thereafter, the matter was listed on several occasions with the noting that no counter has been filed. The respondents filed counter affidavit after lapse of near about 3 years. That is on 15/1/2015, wherein the first time respondents have brought in order in which the petition dated 8/10/2012. There is a provision for filing a review challenging that punishment order. Review was filed, but before the President of India, review was filed. But before any order is passed by the President of India, the original application was filed. That original application, when pending, the President of India rejected the review application. That has never been challenged before the Tribunal. That submission was made because review was made and ultimately that was
No, you
rejected.
could have amended the
Yeah, that
original.
amendment has been made,
Okay.
but the Tribunal held it is not necessary.
Hmm.
That is important.
Okay, just to.
By an order in which petition dated 8/10/12 was rejected by the competent authority by the order dated 13/9/2013. It is noteworthy that petition dated 8/10/2012 was not a statutory one. It is a statutory one. 25A statutorily review provision is there. Review is to be made before the President of India. The wrong noting is not a statutory one. The circumstances hold that provision section 19(4) of the Administrative Tribunal 1985 would apply so as to decide this way on merit. Similarly, we have examined the punishment available under sub-rule 6 of Rule 6, in which punishment available to be imposed under. I have read out in the previous order how it has been interpreted. Now the wrong interpretation has been given by this. They have quoted the Rule 6.6, reduction to a lower time scale of pay, grade, post or service with or without further directions regarding condition of restoration to grade or post or service from which the railway servant was reduced and his seniority and pay on such restoration to that grade, post or service. Admittedly, the applicant has been imposed with the punishment as under reduction to the next lower grade, with the pay being fixed at the bottom of this grade on a permanent basis. That earlier judgment also have read out how this has been interpreted and how wrongly this has been interpreted in the present, at present. On going through the punishment imposed on the applicant vis-a-vis the rules, prima facie the stand is that punishment imposed is not in accordance with the rules, does not sound to judicial conscience. However, it is an admitted fact that all total 58 witnesses were examined by the committee behind the back of the applicant, and the copies of the depositions were supplied to the applicant. But the law requires otherwise. The examination of the witnesses ought to have been made by the committee in presence of the applicant, so that the applicant could have got an opportunity to cross-examine them then and there itself, thereby leaving no room of doubt on the examination of the witnesses. We also agree with the committee that as per decision of the Honorable Apex Court, in the case of Sakhi versus Government of India, a victim need not be exposed to cross-examination so that the victim does not feel emotionally intimidated or harassed, but a question resolves as to what about the witnesses who are employees of the department. It is also a fact that the allegation of sexual harassment is of the year 2004, whereas the complaint was made in 2009. It was for the complainant to explain for the delay in making such allegation belatedly, whereas in the instant case, the committee themselves justified for such delay. It is seen that the complainant made allegation of sexual harassment, whereas the committee traveled beyond the allegation and made several aspersions and accusations on the applicants that he has sexually harassed many lady employees, though this was not the subject matter of consideration.
Sorry to interrupt. There is a prescribed period for which a complaint is to be lodged under the harassment law.
That has been made.
Yes.
Is a continuous harassment. It has continued.
It is continuing.
It is continuing for a long time.
Since 2009.
Yes. I will place the complaint petition itself. I will annex that. I will place the factually very distorted manner it has been written.
Right.
Yeah. One of the observation of the committee as page 99 is reproduced wherein below it shows that how far the report of the committee is acceptable in the eye of law. Sri Ghosh has further stated that none of the persons who have deposed against him were eyewitnesses to the alleged incident of sexual harassment. An eyewitness, how can eyewitness will come to sexual harassment?
Just proceed. No. Yeah.
Who have deposed against him were eyewitnesses to the alleged incident of sexual harassment, and their statements are based on hearsay evidence. It is well-known fact that sexual harassment seldom takes place in open places, and therefore the victim may not be able to produce direct evidence or eyewitnesses in support of her complaint. The issue has to be inquired based upon circumstantial and corroborative fact and evidence. The complaint committee has done exactly the same and has arrived at its conclusions based on such evidence. If it was the case of the committee that the sexual harassment seldom took place in open places, that prevented the victim not to make allegation before the authority controlling the law and order and in the state or before the competent authority of the department. Another observation of the committee, which is very much relevant, is also reproduced herein below. Sri Devashish Ghosh has also raised the issue that the complaints committee had asked Srimati P.U. Banerjee as to who had tortured her to give similar false statement like that Sonali Bhaduri. Incidentally, Srimati P.U. Banerjee has in her deposition dated 24/8/2010 that she and Srimati Sonali Ajay Nath to give similar depositions before the complaints committee as discussed in section 8B 14. Sri Ghosh has alleged that the complaints committee has not taken cognizance of P.U. Banerjee's certification regarding him that he cannot misbehave with any lady. Srimati P.U. Banerjee in her deposition dated 24/8/2010 has admitted that Sri Devashish Court had visited her residence on 22/8/2010, visiting a group D employees' residence by a senior officer in the absence of any specific occasion certainly raises doubt about the working relation between them. Sri P.U. Banerjee, a Group D staff, neither felt disturbed nor raised any objection to Sri Ghosh's visit at her residence. It clearly proves that an unholy nexus exists between them. How can it be lost? A senior officer, they are all Group D employees. Their CCR, everything that depends upon him. And if he visited his place, he will raise objection to that. He is a very senior officer. And it clearly proved that unholy nexus exists between them. And the visit was for personal.
What post he was holding this?
He is a
Senior officer.
engineer. Yes. Senior section engineer, TL Garandis. Head office. In the head office.
His appointment is by President of India.
Yes. He is a very senior officer.
No, that is there. In some public sector undertaking, there are posts which are the appointing authority is President of India. Is it so in this case? Because the advice has come from the President of India. Review is before the President of India.
His disciplinary authority is a board.
Disciplinary authority is a board.
He is a very senior officer. And he is compelling the lady assistants to work in his chamber itself. And if the allegation complaint petition if I will place, the Lordship was surprised how sexually harassed for a long time, even during her pregnancy. She was harassed. He went on leave for a long time. And the threatening is that I will.
So this particular you are placing from which paragraph?
Paragraph 6. Paragraph 6 only.
No, what about that? That no opportunity of cross-examination was afforded to him.
Because the complaint, as per the
it was not recorded in his presence. No opportunity of cross-examination was given, which is provided.
Chance was given to him.
No, he must have taken that stand in the original application, or that. But your counter is that yes, that has been given.
It has been given. Copy of the complaint was given. Entire 58% deposition was given.
No, his grievance is that when the examination of the witnesses were taken off, not in his presence, nor he was given opportunity to cross-examine then and there.
Yes, that was not necessary.
He was supplied the copy
only
later on.
That was not necessary because of the Visakha committee's report. It was there. Everything will be provided to him, giving an opportunity to file objection to that. That opportunity he has availed. He has given his objection. That the matter was considered.
He cross-examined.
Yes. No, whatever he wants, that has been given.
No. This point, which how you say somebody has been 58 witnesses, that paragraph you are placing, paragraph 9, that totally 58 witnesses were examined by the committee. So it is at for that point of time, it is the case of the petition, opposite party in this writ petition, that it was recorded in his absence. Number one. Number two, subsequently, also he was only supplied with the deposition.
Deposition and the complaint petition.
Right, but he was not given any opportunity to cross-examine. Do you mean to say?
That is not provided on the Visakha committee report.
That is the rule. Is there?
That is the rule itself speaks. The rule itself.
Let us see that.
That Visakha committee, according to Visakha committee Supreme Court guideline, a committee is to be formed, and that committee is to inquire into the matter without giving any opportunity of cross-examine, and that report is to be considered and it is to be handed over to him along with the copy of the depositions. That has been done. And the complaint petition itself is to a charge sheet, not a specific charge sheet is to be prepared. The complaint petition is to be treated as charge sheet. The inquiry report is to be treated as the report.
Hmm.
This is a comment report. No further. No
That
department.
is Sakhi case versus UI.
Yes.
A victim not to be exposed to the cross-examination so that victim does not feel emotionally so and so.
Both parties
But
will be given-
he is rightly telling what about the witnesses who are the employees of the, that is only applicable for the victim. That
Because
Sakhi
this
case,
she should not be exposed.
huh?
Because
Sakhi
victim should
case
not be
it's all right. But when you are examining 58 witnesses, one witness victim is all right. But what about the rest?
He could have prayed,
57?
no. He could have prayed, I want to cross
He
examine.
says that
No.
you admit that no opportunity was given.
It has not, yes, an opportunity given, but that is not provided on the rules to give him an
No, no. If this case, then please cite that decision. Let us see that.
At the time of preliminary inquiry,
No, about the Sakhi case, you said that no witness should be allowed but it has been perhaps there in that case it is only stated that the victim need not be exposed to cross-examination. But he has rightly said that what about the other witnesses? That means rest 57.
He could have prayed for cross-examination of them. Well,
No,
that is
provided
scope because
unless you make him that you are at liberty, we are taking off the examination after you examine the victim. Now, once the Supreme Court says that victim cannot be cross-examined, it's all right. But the rest of the thing, you are to intimate them that this is the date fixed for examination of, let us say, 2, 3, 4, 5. You can remain present, you can cross-examine it. That opportunity, he should be made aware about it. He might not be knowing that what is there. So whether there is anything from your side that you intimated him, made this opportunity available, in spite of that he did not avail, that would have been a different.
As per the rules, we have communicated everything to him, giving an opportunity to
That
file
is
the
after the recording.
yes.
So that is why we say that it goes to the root of the matter. Let us say it has been wrongly interpreted. The decision.
In ordinary course, ordinary disciplinary proceeding, that should have been done. But in case of sexual harassment, this is not necessary.
No, sexual harassment.
Yes,
we need to say that the sexual harassment laws, the process in which the committee is to record the statement that is there.
Yes.
How it will proceed in different stages, first cancellation and all that.
Yes. That details will also be given sometime.
After denial of the victim, to even there is a stage of compromise. If it fails, then they will come again. All these steps
that entire procedure I will produce. Give me a chance, I will produce.
Because whether it is applicable only for the victim, it's all right. But if you
there is no scope, because a preliminary inquiry is to be conducted, and that should be treated as a department proceeding. But no second proceeding. Or in normal course, there is a preliminary inquiry. Thereafter, domestic inquiry is to be initiated, and opportunity
yes,
of proceeding.
Here
only preliminary
you harp on it.
Yes, only
it is a preliminary fact-finding committee.
Yes.
Basing on the statement of the witnesses on the basis of affidavit or otherwise, to see from both the sides. Statement will come from both the sides, and the fact-finding committee will preliminarily give an order basing on which the action will follow.
At
No
the stage of preliminary inquiry, there is no scope for
that.
No scope for
the committee will simply see.
Committee will simply submit a report.
You go through that only. So the entire proceeding must have been placed before the court.
Yes. Yes.
So what has happened then?
And ultimately it is found that he has committed the.
No, the court, the tribunal, how he deferred, what are the reasons?
Tribunal has said that the UPSC
made an advice.
That has not been communicated.
That has not been
and the national justice has not been followed. These are the two reasons. Which I said is not necessary, because as per the rules, UPSC advice is to be given at the time of imposition of penalty. And the national justice we have followed, giving opportunity of hearing and everything.
Now this man is has retired or still in service?
Retired.
He must have been retired.
Above 60.
60. All right. WPC number 17617 of 2014. the petitioners have challenged the order dated 7/12/2013.
23.
Sorry, 7/12/2023, passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260/00903 of 2012. In setting aside, we number
903.
Uh,
OA
two-
number 903.
260.
Yes, 903.
903.
No, it is mentioned.
ଲେଖୁଛନ୍ତି ତା ପୂର୍ବରୁ 003 ଟା ଯୋଡ଼ି ଦଉଛନ୍ତି।
No, it is 260 ଯାହା
Page
ଲେଖା ହେଇଛି।
58 ରେ ଦେଖ।
260 page number 58.
260 ହଉଛି ତା ସିରିୟଲ ନମ୍ବର ଫର୍ମାଟ କରିଛନ୍ତି।
ସେଇଟା ହବ।
ସେଟା
903.
903 is the number.
In your prayer, you have mentioned it 903.
903 is the number.
58,
ଏଗୁଡା ତ
57
computerized
page.
purpose.
Page 58. 260/009. Huh.
Hmm.
So, in setting aside the order dated 9/7/2012 as well as the order dated 13/9/2013, passed by the respondent number, in this joint secretary is now the petitioner number 2, right? Petition number 2, and the other orders,
President of India,
acha,
by the President of India, communicated by the Ministry.
and Union of India, respectively. And with a further direction that the opposite party shall be entitled to all consequential service and financial benefit retrospectively. The learned counsel for the petitioner submitted that the first order was passed on uh, 16/2/2018 in OA number 903 of 2012 by the Central Administrative Tribunal, dismissing the original application filed by the opposite party being devoid of merit. And the order was challenged before this court in WPC number 6809 of 2018. And division bench of this court by order dated 21/12/2022 has been pleased to set aside the order and remitted the matter back to the Central Administrative Tribunal for fresh disposal by giving opportunity of hearing to all the parties without expressing any opinion on the merits of the case. It is submitted that when the matter was remanded back, it was reheard, and the presiding officer took a completely different view, which is not in consonance with law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. requisites for issuance of notice to the opposite party by speed post with proof of delivery shall be filed within a week. Matter to be listed 4 weeks after. Counter affidavit, if any, be filed in the meantime, serving copies thereof on the land council for the petitioners. Had Mr. Sanjeev Swami Upar Lekhi, senior panel counsel for the petitioners. Okay. Yes,
Interim order is there, the operation of the interim order is still.
there was a, what direction was issued ultimately?
You pay the entire benefit within 6 months.
60 days.
Within 60 days.
Just a minute, let us see this. Entitled so and so. IA number 8265 of 2024. There shall be, after hearing the land council for the petition, and there shall be a stay of operation of the order dated, impugned order dated 7/12/2023, passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 903 of 2012 until further orders. No?
The IA number is 8265.
Huh?
IA
8265.
8265.
8265. Huh? 8265 of 2020. Yeah.
Next.
Item number 15.
May I please, Lord? I challenge the order of the Lord Central Administrative Tribunal, Cuttack Bench, Cuttack, dated 7/9/2023 at page 80 in OA number 227 of 2020, Your Lordship, Annex of 5. It is a case, Your Lordship. This present petitioner retired from service on 29/2/2020, Your Lordship, at page 25, Your Lordship. Dated 3/2/2020, given that after completion of 60 years, attaining the age of 29/2/2020, Your Lordship.
Please come to the operative part of the impugned order, then we'll.
Yes, Lordship.
That is
Page
84, no?
Page 83, sir.
Huh?
Page 83, paragraph 6.
Paragraph 6. If that rule has been quoted.
Yes, that is the.
All right, please place that. Rule 39.
Rule 39(3) of CCH leave rules provides as under. Rule 3. The authority competent to grant leave may withhold whole or part of cash equivalent of earned leave in the case of a government servant who retires from service on attaining the age of retirement while under suspension or while disciplinary or criminal proceedings are pending against him. If in the view of such authority, there is a possibility of some money becoming recoverable from him on conclusion of the proceedings against him, on conclusion of the proceedings, he will become eligible to the amount so withheld after adjustment of government dues, if any. 7, Your Lordship. It would be imperative to point out that in OA number 13/2017, in which the applicant had challenged recovery of 3,60,000, which was disposed of on 12/7/2021, which was quashed, at the order of recovery of 3,60,000. That is in quashed. Meanwhile, OA 299 of 2015, in which the applicant had also challenged the recovery of 1,19,902, was dismissed on 11/8/2023, where it is both are the Rule 16 proceedings and recovery of the minor penalty has been awarded. In 1,19,902 is already recovered for the 30,000, Your Lordship. And therefore, out of total recovery, that is rupees 9,83,387, the respondent is claiming the recoverable amount is rupees 6,23,387. It is admitted that the leave encashment is due 6,23,000. However, it is stated that counter that the total entitlement of the applicant towards the leave encashment is rupees 6,53,387, which also depends on the determination of his period of suspension, which further depends on the outcome of the criminal case that is pending before the learned CBI for Bhubaneswar. The citation relied upon by the learned counsel for the applicant are not applicable to the facts and circumstances of present case, Your Lordship. As provided in rule quoted above, the competent authority, if so arrives at a conclusion that there may be some amount to be recovered from the applicant on conclusion of a disciplinary or judicial proceeding pending against him, then he can withhold the leave encashment which the applicant is entitled to. The respondents write letter dated 15/4/2020, Annexure 6, that has been in OA, have already clearly intimated the applicant the amounts that is likely to be recovered from him. After an in-depth hearing of the matter and as per the discussion made above, this tribunal doesn't find any irregularity or illegality on the part of the respondents warranting intervention in this tribunal, Lordship. What happened, Your Lordship? Lordship, in my OA, page 25, I have page 25, Lordship.
25.
25.
Yes.
Retired from service 29/2/2020, Your Lordship.
Just a minute.
On superannuation, Lordship. Last line, sir. And thereafter, Lordship, page 27, 11/3/2020. 11/3/2020.
27.
page 27.
27, yes.
11/3/2020. That is the sanction of the provisional pension, Lordship. Thereafter, I made the representation for the leave salary and other salary, Lordship. In page 29, next page, Lordship. In my representation, first inviting 2/4/2020. Inviting reference to the above representation, it is to inform that the provisional pension such and such with usual DR and IMA has been sanctioned with effect on 1/3/2020 for a period of 6 months by office letter event number dated 11/3/2020. This has been sanctioned as per the account and enforcement issued by PO Kotak by letter date of 27/2/2020. Due to wrong pay fixation of pay with effect on 1/1/2006, consequent upon revision of grade pay of inspector post from 4,200 to 4,600, the pay has been regulated correctly from 1/1/2006 to 18,16 as rupees 18,020 instead of 18,420. Similarly, the last pay of the for the month of February 20 has been fixed such and such instead of such and such excess payment. These excess pay and allowances with effect 1/1/2006 to 29/2/2020. That is the last day of retirement. After retirement, it has been calculated. As per the Rafi Prasad case, Lordship, court held that after retirement, it cannot be revoked, Lordship. And in view of the government OM in 2017, this has been, that is GP grade pay is 42,000 to 46,100. It has been calculated and given by them, Lordship. And also, Lordship, Honorable Apex Court that is in 2020 that on misrepresentation they have to or fault of the petitioner that can be recovered, Lordship. There is no fault of the petitioner. So recovery amount they have on 2006 to 29 to 2000 will be recovered. Also, there is an outstanding of 4,79,902, Lordship. That is from 1/1/2006 to 29 to 2020. That excess payment, that's it. Which is pending of recovery due to stay operation of the CAT order, operation of the Honorable CAT Kotak bench. Rupees 15,500 is pending without adjustment treasury. HO and 4,884 is due for recovery towards excess paid such and such, Lordship. So, Lordship, thereafter, Lordship, they again, that is the next. 2020. Amount on which basis they recovered last 4 columns. 4,79,900 is pending due to stay order of Honorable CAT. Both the cases are disposed of as per the order says. Way number 13 of 2017 already been quashed, Lordship. That is 3,60,000. The rest part is 1,19,000. And rupees 15,500 treasury advance is pending. That is the pending, Lordship. And 4,884, that is excess payment, that is the TA and DA. This accrues within the 2 lakhs, Lordship. And 4,27,300 excess paid allowance from 1/1/2006, that is the excess payment they said, that cannot be recovered by the authority because in view of the Honorable Apex Court judgment, Your Lordship. But they have, as per counter as well as the admitted facts that the leave encashment is 6,70,000. That may be paid the rest amount, Your Lordship. And till
That
today,
is for 190 days.
Your Lordship.
190 days.
Yes, Lordship.
That they have taken into calculation.
Yes, Lordship.
Although it is 9 lakh something, they have taken the calculation up to 6 lakhs
Yes,
for
Lordship.
190 days.
Yes, Lordship. 190 days.
Maximum.
So it cannot be, excess payment cannot be recovered. And that apart, first 13 of 2017, first which has been cost, that is 3,60,000. So it amounts to within the 2 lakhs, Your Lordship. Out of 6,53,000, he may disburse the amount, the leave encashment of 4 lakhs something, Your Lordship. And that apart, Your Lordship, I have challenged that is, but in counter, they've said such and such, and
All
all
right. The petitioner, Radhakrishna Sahu, has filed this writ petition challenging the order dated 7/9/2023 of the Central Administrative Tribunal, Cuttack Bench, passed in OA number 227 of 2020. So also, the orders passed by the disciplinary authority dated 2/4/2020 and dated 15/4/2020 under Annexure 1 and 2 respectively, with a further direction to the opposite parties to disburse the amount of leave encashment due to the petitioner as per law. The Learned Counsel for the petitioner placed the order, impugned the order, and submitted that it is not in consonance with law and against the ratio laid down by the, what is that Rafi case, the citation, please give it. Ratio laid down by the Honorable Supreme Court. ଦିଅନ୍ତୁ ଆମେ ଜାଣିଛୁ ଯେ ଅର୍ଡରଟା ଦିଅନ୍ତୁ ସୋ ସେଇ ସାଇଟେସନଟା ଦେବେ ଲେଖିଦେବେ ହେଲା ସେ ରଫି କେସ୍ ଆମର ବି ହେଇଛି ଚିଫ ଜଷ୍ଟିସଙ୍କ ସାଙ୍ଗରେ ଅର୍ଡରଟା ହେଇଥିଲା issue notice on the question of admission indicating therein that the matters shall be disposed of at this stage of admission. Requisites for issuance of notice on the opposite parties. There is no need to issue notice to the opposite party number 6. No need to notice to opposite party number 6. Requisites for so and so. Acha, you Mr. Pari, you accept the notice. You accept notice for OP 1 to 5.
1 to 5 is register is not a necessary party.
Right. Mr. This one so and then notice accepts for OP number 1 to 5. 5 sets copies of the writ petition be served on Mr. Pari. Any council, central government council, if you want to say, we can name it.
Mr. B.K. Padi is appearing with me, my lord, is with court.
Acha.
Mr. B.K. Padi, Virendra Kumar Padi.
Virendra Kumar Padi.
Yes. He's
Okay, Virendra Kumar Padi, Learned Central Government Council. Within a week, you summon. And matter to be listed 4 weeks after, counter affidavit, if any, be filed in the meantime, serving copy on the petitioner's counsel.
Okay.
Item number 16,
May I please, Your Lordship? My Lord, petitioners have filed a petition under section 28A of the Land Acquisition Act before the opposite party number 3 for enhancement of the award and to redetermine the compensation amount, my lord, for their equal land, my lord. The OP number 3, after verification of the documents, found that the claim of the petitioners is genuine and they entitled for higher compensation under section 28A of the Land Acquisition Act, my lord. As per the judgment of Honorable Senior Civil Judge Noapada in LAR number 132/2010, my lord. After that, he calculated the higher compensation and decretal dues in favor of the petitioners, and as per the judgment, and submitted the calculated calculation sheet and decretal dues payable to the petitioners by letter dated 1626, dated 22/11/2023 before the opposite party number 2, my lord, which is at Annexure 1 and Annexure 2, my lord. But since 22/11/2023, my lord, opposite party number 2 is not taking any steps to sanction and dispersal of the same, my lord. It is pending before the opposite party number 2, my lord.
So the annexure 1 has been issued, and wherein it has been held that the claim of the petitioner is genuine.
Genuine, my lord.
And the petitioner is entitled for higher
Higher
compensation
compensation, my lord.
as per the judgment of the so and so.
Yes, my lord.
Then a copy of the so and so is attached to. So it was forwarded to director R so and so. That is the opposite party number
2, my lord.
2. So when this, it was 22/11/2023.
Yes, my lord.
So he has to act upon this.
Yes, my lord.
Okay. Why are you delaying the matter?
Madam, give me 7 days time, I'll take instruction.
Just take instruction.
10 days time.
Okay. The London Council for the petitioner drew the attention of this court to Annexure 1, which is the letter dated so and so, issued by the opposite party number 3 to opposite party number 2, wherein it is mentioned that the claim of the petitioner is genuine and the petitioner is entitled for higher compensation under section 28A of the Land Acquisition Act 1894 as per the judgment of the Senior Civil Judge Noapada in LAR number 132 of 2010. The Land Council for the petitioner submitted that even though the recommendation was made way back in 22/11/2023, but no action has been taken by the opposite party number 2 for dispersal of the amount in favor of the petitioners. Land Council for the state has received the copy of the writ petition and seeks 10 days time to obtain instruction from opposite party number 2 put up this matter in the week commencing from 12th August 2024. Okay.
Item number 17.
In this matter, petitioner is challenging inaction of this DM Hon'Ble for not disposing the miscase filed before him to depute a police commissioner to take over the possession of this land in question, mortgage land in questions, and to hand over to the petitioner.
Petition.
My lord, that is whole. My lord, law is statute is saying that it has to be due within 30 days. If it is not with reason 60 days. But
Yes,
he is
so
I
that
have
Provision.
14.
Yes.
Section 14.
Just a minute.
Right.
No. Why are you, why? That
My-
book is surface area.
Surface. Section 14.
Just,
Madam can go to page 34.
34, why wrong?
This.
Okay.
Section 14 and schedule IX.
Section 14,
14
Hmm.
and IX of 9.
9.
I read
Yeah.
that the provisions of thus Act and the rules made thereunder had been complied with, provided further that on receipt of the affidavit from the authorized officer, the district magistrate of the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable order for the purpose of taking possession of the secured assets within a period of 30 days from the date of application.
Hmm.
I
What is the
again
extension
further
proviso?
provides 9,
Ah.
my lord. And next parameter, just provided further that if no order is passed by the chief metropolitan magistrate, since in writing for the same, pass the order within such also period, but not exceeding in aggregate 60 days.
Hmm.
But in this case,
When
my
the
lord,
application was made.
my lord, kindly see page 17 of my writ petition. That is annexure 3. 3/1/24 I have applied for them. 3/1/24. Just, my lord, page 17, last place Sambalpur, date 3/1/24. 17 last line.
So that means 17 ହେଲେ ପ୍ରଥମେ ହେଲା 30
ତିନି
ଦିନ
ଏକ।
ତାପରେ ଆଉ ହଉଛି
3/1,
ଠି ମାନେ
3/2,
total
3/3 ଭିତରେ
period ହଉଛି 90 days.
60 days. With within 60, no,
Within-
within such also period, but
but
not
not
exceeding in aggregate 60
अच्छा,
days.
60 days. अच्छा. So, Mr. Counsel for the state,
My lord, this application is defective. Your lordship may see Annex 3. That is not supported by any affidavit, man. Your lordship may see 14,
yeah,
first proviso.
first proviso, yes.
14, first proviso, provided that any application by the secured creditor shall be accompanied.
Oh, could just a minute. Just 14 wrong.
First proviso.
Shall be accompanied by an affidavit.
Affidavit.
Provided that any application of the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor declaring that. Okay.
But thereafter also, my lord, my learned senior relied on 9 that the provision of this act of the rules made thereunder had been complied with, provided further that on receipt of the affidavit from the authorized officer. This is not the affidavit, my lord. Your lordship may see Annex 3.
No, it is affidavit, my lord.
There is no
Affidavit
accompanied
is
act.
there, but it is not.
Because one of the point of satisfaction of the DM or the chief metropolitan magistrate is that it is a secured creditor. That is and secured asset. That is the satisfaction of the authority.
This is a defective application.
Provided further that on receipt of the affidavit from the authorized officer.
The authorized officer, the district magistrate or the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable order for the purpose of taking possession of the secured asset within a period. It was affidavit is there, but here how it has been missed.
That
Where is the affidavit that he is harping on that?
affidavit is there, my lord.
You should have
Affidavit is
filed.
there. That has means, I think, not attached, but he cannot sit over. He has to dispose of. If affidavit is not there,
If it is not on the basis of that.
it is not basis, so he should have disposed of the matter, saying therein that if it is not there, my lord can pass fixing a date. Usually, my lord, what?
No. If have you taken instruction
No,
that
no,
it
no,
is
my-
not? So
this
that,
is
oh,
part
Asha, you are just. We thought that you have perhaps taken instruction
no.
that it is not
No,
supported by the affidavit.
No, but they have filed the.
Take instruction.
my
It's
lord,
just
they-
a matter.
We are not on.
My lord.
This Lekhandu, this writ petition has been filed by petitioner Bank of Baroda with a prayer for a issuance of writ of mandamus directing the opposite party number 1, collector and district magistrate on Gould, to authorize any officer subordinate to him to take over physical possession of the assets and documents and forward the same to the petitioner secured creditor within a stipulated period. The learned counsel for the petitioner drew the attention of this court to the application made by the petitioner before the opposite party number 1, which is dated 3/1/2024, and further placed the two provisos to section 14(1) X IX, and submits that the period stipulated is already over, but no order has been passed by the opposite party number 1. The Land Council for the state, on the other hand, submitted that the application which has been annexed to the writ petition by Annexure 3 is not with the affidavit duly, it is not accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor. And that is why the application itself is defective. The Learned Counsel for the petitioner, on the other hand, that inadvertently such affidavit has not been filed with annexure number 3, but such affidavit has been forwarded to the opposite party number 1. Let the Learned Counsel for the state verify whether the application filed under annexure 3 before the opposite party number 1 is in accordance with law, and whether any action thereon has been taken by the opposite party number 1 or not. I spread for less this matter will be commencing from 12th of August 2024. We serve an extra copy so that extra copy of the petition be served on the Land Council for the state. Yes.
Item number 18.
Yes, Mr. S.K.Sahoo. Okay, not there. Next matter.
Item number 19.
On behalf of Mr. Kejriwal, kindly matter day after tomorrow, my lord.
No, it is to come next week, not tomorrow, day after tomorrow. A mention is made on behalf of Abhishek Kejriwal.
Yes, ma'am.
for adjournment till next week. List this matter and we commencing from 5th of August 2020. Yes.
Item number 20.
Yes, Mr. Das.
May I please, Lordship? A poor person has been harassed at the waste of the government organization, that is the Irrigation Department. A poor person who was possessing only.
Now the poor person can entrust brief to Mr. Das.
I'm so sorry.
No, we are.
I'm not taken. While I have seen that, I'm not
Okay,
taken
okay.
brief only.
Please proceed. Yes,
So,
yes.
the
So,
person who he was cultivating his land, at that time, the irrigation department constructed a ridge forcibly upon his plot pile. While he has ventilated a grievance, nobody has paying any heed to his grievance.
where is
Now,
your representation?
my lord, that is annexure two.
What is the date of that representation?
That is date, my lord.
That postal.
Annex postal page 12, my lord.
Please see that date. We are not. We see
10/5/2024.
10/5/2024. You have not got any response
No,
from them.
till today not.
All right, you dispose of that representation, the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner, the petitioner has filed this writ petition with such and such prayer and is submitted that highlighting the grievances representation has been made before the
Opposite part number 2.
opposite party number 2 on such and such date. कभी 10/5 ना कितने लिखा जी 16/5 बोले नहीं 10/5
10/5/2020.
action has been taken thereon and the petitioner has not been communicated any order. Then with the usual order per again without expressing any opinion on the merits of this one. So 3 months time is granted from the date of production of the certified copy of the order, and the order is to be communicated to the petitioner also. Yes.
Okay.
Item number 21.
Item number 21, matter relating to acquisition of land. And similar matter, justice has disposed of the representation by a coordinated base of the Honorable Court, directing the
Where is your representation?
representation Annex 3, that is advocate notice on behalf of the petitioner.
You have not received the compensation for that.
No, my lord, what happened in the year 2015, my land was acquired for
This
it.
is already decided by Supreme Court.
But
In the matter of Steel Authority of India Limited, a vast land was taken by the Rourkela Steel Plant. Many of the land could not be utilized. And for that, the petition was filed by the persons, landless person, those who the land were taken on acquisition. They said that since the land is not in use and instead it is being leased out in favor of other parties, why not it be returned to us? The analogy has been given by Supreme Court. It has been decided, set at rest. Once you have taken the, received the compensation, you have no right to take the land return because there are various purposes for which.
if it is acquired by the author as per 102 million of the new act, then if the land is acquired by somebody else in a consideration amount, then proportionate amount can be put. To that, I have filed a representation or filed to consider that. Only representation.
Where is that? Annexure 3?
Annex 3, Miller.
Annexure 3.
Yes.
All right. This writ
Annexure
petition
4,
has
sorry.
been filed.
Annexure 4.
Annexure 4.
4, acha.
Dated
Default of number.
Petition has been filed by the petitioner so with following prayers. Prayer quote kar debe. Same like the way representation has been made by Annexure 4, before the
OP number 1.
So OP number 1, na?
Yes, OP number 1 is to
on 11/9/2023. But no response has been received. Same time limit, same order from the date of production of the copy that is to be disposed of within 3 months. Yes.
Item number 22.
May I please, Your Lordship? My Lord, this matter is very similar with item number 17 matter, my Lord.
Item number?
17.
17.
My lord, the person is aggrieved by the inaction of the district magistrate Khordha that he is sitting idle.
Okay, so you obtain instruction, Mr.
My lord,
that why it has,
no, my lord, this is a different matter.
Sorry? You said that similar matter, again you say
I
different
beg your
matter.
pardon, my
Then
lord,
you place the matter.
My lord, the present petitioner is aggrieved by the inaction of the district magistrate Khordha that he is sitting idle over the matter since 7th October 2022, my lord. There are no not taken any
Your
state.
petition number is 188 of 2022.
My lord,
And it is pending before the opposite party number 1.
my lord,
So you want disposal of that.
my lord.
That's all. So time limit fix up for the disposal for the time limit like 3 months from the date of production of the order. Dispose of the case bearing petition number so on. They are the key like him. Yes, next.
Item 23.
My lord, this is the matter of a situation. My lord, in between, ocean notice has been served to the person. Kindly give us liberty to approach before appraisal form.
Indian Bank. Who is for the Indian Bank? Any counsel is there for Indian Bank?
My lord,
And what you have submitted representation is all right, but time without number, the Honorable Supreme Court has said that don't entertain the writ against the notice under 13(4) of the Surface High Act. So there is an alternative remedy available to you. So the method which you are now adopting, that you have filed a representation and seeking a direction to dispose of that representation, that means you are indirectly taking that order which is against the decision of the Honorable Supreme Court. You have a forum available. You approach that forum. I will direct the the writ petition has been filed by so with a prayer to quash the notice under 13(4) of the Surface High Act under Annexure 2, and with a further direction to the opposite party bank to waive the penal rate of interest and allow the OTC facility to the petitioner and reface the loan in order to allow the petitioner to pay the loan amount on easy suitable installment. The Land Council for the petitioner submitted that a representation has been filed by the petitioner before the opposite party number 2 on 25/3/2024, and same may be directed to be disposed of in accordance with law. In the case of so they say that it has been held that it is not maintainable. Therefore, we are not inclined to pass any order disposed of. Yes, next. Alternative form is available. We will give the citations to you.
Item number 24.
Please, my lord. My lord, here the present petitioner is a landless person and also applied before the Tahsildar. My representation is pending by the Annexure 3 to settle the land under OGLS Act.
Annexure 3 is your, when it was
party number 4, Tahsildar Kandhamar.
When it was filed on 8/4/2024.
My lord.
Okay.
Later Tahsildar will take a decision stipulated time.
Application is dated 8/4/2024 and pending before the opposite party number
4
Tahsildar
Kandhamar.
And 3 months time granted for disposal of the representation. Same order to pass.
Acknowledgement.
Yeah.
Item number 25.
Yeah, please.
Here, my lord, I'm challenging the e-auction notice issued by the Bank of India. My lord, only on the ground, my lord, that without giving any notice under section 13(4), my lord, under the Surface Act, he issued a e-auction notice by auctioning the petitioner's plot as well as residential building of the petitioner. Though the petitioner is not defaulted in the paying the installment amount. If your lordships kindly see, my lord, Annexure 1, my lord. Sorry, my lord, Annexure 2, my lord. Page 14. I incurred loan 10 lakhs.
Just to come to that, you are raising a legal point. So let us say that first the notice was issued under 13(2).
13(2), my lord.
Then you come to the operative part of that notice. That is page number 18.
18, my lord. Paragraph. My lord, paragraph 7, my lord.
Paragraph
7.
Huh.
If the said dues
are not fully recovered
with the proceed realized in the course of exercise of the said power against the secured asset, we reserve our right to proceed against you before debt recovery tribunal. Quote, for recovery of the balance amount due, along with all cost incidental thereon from you. Please take note that as per subsection 13 of aforesaid Act, after receipt of the said this notice, you are restrained from transferring or creating any encumbrances on the aforesaid secured assets, whether by way of sale, lease, license, gift, mortgage, or otherwise. The undersigned is duly authorized officer of bank to issue this notice and exercise power under section 13 aforesaid Act, my lord. Thereafter, I filed a grievance petition to the opposite party, and opposite party send a reply to my grievance petition, that is Annexure 4, my lord. My lord, the operative part is page 20.
No, after 13(2).
My lord.
13(4) has been not given. How do you say so?
My lord.
They have straightway gone to e-auction.
My lord, that is the.
ଲେଖା ହେଇଥିବ ନା ଆପଣଙ୍କର?
My lord, they have submitted.
ଲେଖା ହେଇଛି ଦେଖନ୍ତୁ ଆପଣଙ୍କର ନିମ୍ନ ସୁଆଂଶ ଦ୍ୱାରା ଆଇନ ଧାରା 13(4) ସହିତ ଅନୁଯାୟୀ ନିମ୍ନଲିଖିତ ସମ୍ପତ୍ତିକୁ ଏଇଟା ସବୁ ଲେଖା ହେଇଛି କେମିତି କହୁଛନ୍ତି ଆପଣ?
My lord, that is my only submission. They have not. If they have
also replied
with lordship's permission.
Annexure 4,
my lord.
The representation can't be entertained as the period of objection. Representation has left long back and bank has already initiated action under section 13(4).
13(4) କହୁଛନ୍ତି ଆପଣ?
My lord, with lordship's permission.
You challenge it before the.
My lord, kindly visualize, my lord. With lordship's permission, I have
an appropriate forum available.
My lord, my humble submission before lordships, my lord.
Sorry, sir.
They have
this petitioner has challenged the e-auction notice issued by the Bank of India. That is the opposite parties, opposite parties. It is the contention of the Land Council for the petitioner that after issuance of the notice under 13(2) of the Surface Act, no notice under 13(4) has been issued by the authority. However, on the face of Annexure 5, it appears that the action was taken subsequent to the service of Surface notice under 13(2) and 13(4) of the. Moreover, in view of the decision laid down by so and so, the petitioner has alternative forum available, so disposed of. Yes, next.
My lord, I am for the opposite party bank
Please give the name so that your name can be.
My lord, position notice of the 13-4 has been issued, my lord.
That is there, that we said that it is mentioned
My
there.
lord, my humble submission before lordship.
All right, you approach the other court and.
My lord, without
raise your-
giving any 13-4, how can I file the appeal, my lord? That is my only ground, my lord.
Yes, yes, that has been already, he is now showing you, send him a copy to that.
Yes,
If your client has not given you proper instruction, take that and show it to your client. Because it would amount to suppression of the fact in the writ petition. Notice has been served on you and it is suppressed in the planning council is showing you that 13-4 notice to you. Yes. Next.
Item number 26.
Notice is received under section 13(4) of the Surface Act, my lord, and the date of sale has been fixed to the 23rd July, my lord. By the annexure 4, my lord. And in this case, what happened prior to the notice under section 13(4), we have approached the bank on 28/5/2024 and ready to pay the 2 lakhs rupees for settlement of my dues. Original dues is 2,50,000. On thereafter, it revised, it come to 12,52,421.
And challenge the matter.
The bank and bank would have done it.
My lord,
What is the question of approaching this?
they are not entertaining my prayer, my lord. And the sale has not been commented.
Alternative forum available, disposed of. Yes, next.
Item number 27.
May I plead your lordship? The petitioner's land were acquired for the purpose of Parindravati project, your lordship.
Yes.
The petitioner's land was acquired for construction of canal under Upper Indravati Irrigation project, your lordship. And the notice was issued by annexure to page 111, your lordship. Where and page 12, Ranagodo and Arthogodo, both are recorded tenants, your lordship.
You have not got the compensation or what?
No, your lordship. There, your lordship, page 12, bottom line, your lordship. Is because the
Since when your land was acquired?
it's acquired since 2010, your lordship, 11, your lordship.
Have you received a part of the compensation amount or totally not received?
Nothing
Nothing has been this.
There, your lordship. Here, the petitioners are the Chankar Chakran Sattu under Faitile.
And have you filed any representation before
Yes,
the
your
authority? What is the representation dated?
Dated 24/1/2024, your lordship.
All right.
Earlier that I have approached many times, your lordship. Enter villagers also filed a representation under under page 14.
Let them consider the representation. Prayer likhi degi nahi. Representation is under annexure 3 dated so and so 24/1/2026. So 3 months time is done and the order is to be communicated. Okay. Yes, disposed of.
OP number 3 and 4.
OP number 3 and 4 are the authorities. Yes.
Item number 28.
And the auction is fixed to tomorrow, my lord. There is alternate is available. I may be
Go.
protected till.
Sorry, no question of protection here. You can go when you filed it on the case here, you could have filed very much there also.
Yes.
So there was no bar. Same disposed of alternative forum is available.
I am for the opposite party, ma'am.
Please give the name and your for which opposite party or all the opposite parties.
Read copy not served.
Indian Overseas Bank. They don't they don't opposite party. Yes, next.
Item number 29.
Mr. Mohanty. Yes.
I am for the petitioner.
Yeah.
Well, petitioner here challenges the order of the ADM. In fact, prior to that, the petitioner is the purchaser from the original lessee in the year 1984. And while mutating, she could came to know that the lease has been cancelled. Then the petitioners have approached this honorable court, and the matter was remanded to ADM for fresh disposal. This matter took the impugned order was passed.
Please come to the operative part of that order dated.
Yes. Order is at page 71.
No, the operative
74.
part is 79.
Operative 79.
Considering the above facts and circumstance. Come
Yes,
to that.
Maharaj. In fact, prior to this impugn order, this proceeding was taken up de novo after direction by this honorable court. When the in fact, this prior to this, after remand, in fact, in this order also it is reflected on which grounds the lease was resumed, lease was cancelled. At para 75, these were the original three grounds.
No, please come to 79. Just you can
page 79 last part.
just last paragraph place କରନ୍ତୁ ତାପରେ ଆପଣ argument କରିବେ କି?
Considering facts and circumstances, I am of the view that being a government servant, a resident of the other district, the original lessee was not eligible for settlement of the land. He obtained the lease by suppressing the fact leading to fraud. The contentions of the present petitioners are not justified as the purchased land is a leasehold land, and by purchasing the same, the illegality cannot be legalized. The revisional authority has right while passing the order dated 27/8/2011 in revision case number 7 of 84, and the grounds taken by the present petitioner merits little consideration and hereby rejected. And the lease granted by the Tahsildar Bhubaneswar in Westland case number 518/5 of 1970 to Husik Bera is hereby set aside. Accordingly, the revision case is disposed of. Well, this is the finding of the in the impugned order. This impugned order, this proceeding was taken up de novo, further to direction by the this honorable court. That is order is at page 70.
No, against the order dated 6/10/2023, you approved this court earlier.
The other order, my lord.
No, you are now challenging the order dated 6/10/2023 or not?
Yes, my lord.
Okay.
In that
So,
order,
when you approve this, this order has been passed by the ADM on 16/10/2023. So, whether there is any other forum available for you or there is no other forum?
There is no other forum, my lord.
Let us see that ADM's power under the revision. Which is the provision?
7A3.
Just let us see.
Prior to this, this petition has approved twice before this honorable court.
Please. 7A3. Please place it.
So this is the jurisdiction.
Please read 7A.
Seven A is revision.
Yes.
And the collector may revise any order made under subsection 1 or subsection 3 of section 7 by sub-divisional officer of the Revenue Divisional Commissioner, may revise any order made under that subsection by the collector if an application is made by an aggrieved person with a period of 90 days from the date of this order. Provided that collector or revenue Divisional commissioner, as the case may be, may admit an application under subsection after the expiration of a period of 90 days for delay condonation. All application 2 is all application revisions under subsection 1 shall be heard and disposed of in such manner as may be prescribed. And 3 is notwithstanding anything contained in this act or any other law, the collector may, on his own motion or otherwise, call for and examine the records of any proceeding in which any authority subordinate to him has passed an order under this act, for this purpose of satisfying himself that any such order was not passed under mistake of facts or owing to a fraud or misrepresentation or on account of any material irregularity or procedure, and may pass such orders there as he thinks fit. In fact, this the original order.
This is a suo motu revision.
Suo motu revision. Suo motu revision based on a report.
Right. So, what is the ground that has been taken by the or mentioned by the ADM to set aside the lease granted in your favor? The grounds is that you have committed fraud.
No,
You
that
have,
was not, that was not the ground, my lord.
Please come to the operative. Again, we are saying that what are the grounds? How do you meet it? You are a government servant. You are a man of different districts, and therefore you are not entitled to the lease. You are not, but you have misrepresented and committed fraud for which you were granted that lease. That is the
original
fine.
lease was granted, my lord.
So, under what circumstances a lease can be granted under this particular act?
Yes, my lord.
Just come to that.
That is
Who are entitled to get the lease?
a landless person, my lord.
Please come to that.
Landless and your income criteria is there.
And my lord, landless also subsequently has been held by this onward as a homesteadless person, and person also has been defined with income. Even the person is defined in B2.
No, please show the provision.
Section 3B2, a person is been defined. Person is defined in section 3, section 2, B2.
We are asking a pertinent question to you, that if everybody can get the lease of the government land, or there is some kind of restriction imposed in that 1962 acts, that these are the person who are disqualified or are not eligible to get the government land on lease. So if that is there, then you please show the provision and how, in spite of the order passed by this ADM, how you say that there is the ADM has committed any illegality in passing the order. He has assigned some reasons.
Well, that is at page 44. The original proceeding was initiated on the basis of a report of the sub-collector SDM of the ADM that is available at page 44, that is annexure 6. And on that basis, the
this is, you are not again showing us the provision. If you are not ready, get prepared yourself.
Very clearly, he is giving the assigned the reason in point A, B, C.
My lords, that is the ground. That was the original ground.
How do you counter that?
Yes, that is the thing which we are asking you.
In the impute
If
order,
a government servant is not landless person by that.
Well, some like in page 44, annexure 6, on 3 grounds, the lease was cancellation proceeding was initiated. There I was not a party. Then when I approached this honorable court, the matter was remanded to ADM for fresh consideration.
Yes.
Then the order dated.
Anyway, by then it came to the notice of the ADMs. That is how he has taken it so moto.
No, in fact, he cannot take that ground. So that was the ground in the earlier rate. And then this honorable court.
The ground of fraud cannot be taken.
He cannot take after beyond limitation, after the period of limitation. He cannot.
Fraud can be taken. That it can be taken at any point of time. There is no point of limitation there.
In fact, those points are raised in at page 71.
It goes to the inception, Mr. Counsel. It goes to the root of the matter. If you are committed fraud and got the land on lease, that goes to the root of the matter.
Well, so
there is no question of limitation there.
For that, a notice was required to be issued to the original lessee. That was the contention in writ number at annexure 71. Annexures at page 71, that annex is appearing.
If your application itself contains the incorrect statements, and by relying on that, the lease has been granted, which was subsequently detected, and revision power has been suo motu, revision power has been initiated, and it was found that yes, you have committed fraud so that is how it has been cancelled. So how you say that the order is illegal.
And managed in Annex 10, that was in the writ petition 31718 of 2011, it was my contention that the ADM has passed an order without issuing a notice on the ground of the contemplated ground of a person who was holding a who was a government servant. Because the only grounds in the impugned order he has mentioned also the original grounds on, and that is yet available.
The
on the,
earlier order which you are referring to, that is 25/2022. That is Annexure 10 series.
Mileage.
You please come to the operative part of that order. The petitioner will appear before the ADM Bhubaneswar along with a downloaded copies. The ADM is requested to pass a rescind order after hearing the parties and dispose of the same within swan. So everything has been done. You have been afforded opportunity. You have been, the order is a rescind order.
In fact, here the ground was like the lease has been cancelled on a new ground without issuing a notice. Because earlier notice was issued for violation of 3 grounds to the original lessee. We were subsequent purchasers. On the basis of liberty given by this honorable court, my matter was taken up by the ADM. Then on this writ petition, it was contended that now the lease is cancelled on the ground, which was no notice was given for that.
For that, he will be aggrieved. No, the original lessee will be aggrieved.
He has died and the order has been passed against a dead person.
All right. Let him come. Anybody repenting?
Even the
how you are affected.
Even the impugned order, yes, I am affected.
Your case is a clear case of fraud. With regard to the
I am not
aside of the original lease, the person's legal heir will come and challenge it.
So, but the proceedings
you are talking of 550 of 70. 515 of 70.
Mileage?
You are talking of 515 of 70.
Well, that is double L case number. So in this present order, impugned order, it has been passed against a dead person. His legal heirs should have been implemented, and the new ground of contemplated ground of cancellation of lease should have been served on him.
So he is the person from their side. You are from the side of the lessee in 515 70.
No, I am a subsequent purchaser.
No.
You can come directly.
In Annexure 7, these were rates of 1992, where I was, my case, it was remanded for trace adjudication, giving me opportunity. That was heard. There a new, on the lease was cancelled on a new ground. There is no report, nothing. Even there is a limited scope.
You can file appropriate case against that person or the legal heirs for getting return of the amount which you have been paid to them.
But they cannot take up a ground after so many years. After 40 years, they cannot.
But how can you challenge that one? You are not the person. You have no locus standi to change it.
But I have been given.
Your case has been dealt with in this case.
No, my case.
How you are challenging that case?
In fact, in this impugned order,
the agreed person.
Impugned order, they are saying original lessee is a deceased person, and the honorable court directed to proceed as per law after giving a notice. Supposing his ADM wanted to cancel on that ground, he has to give a fresh notice. Because original at page 75, what are the grounds it is mentioned? 1, 2, 3. Only 3 grounds. When these 3 grounds are met, he cannot come up, even there is no material on record that he is a government servant. And we cannot say whether he was a government servant or not at this point of time. So the original lessee, or there should have been proper notice for this 4th ground. There is no ground on this impugned order. So, and that apart, this impugned order, it has been dealt as if it is held, he is hearing a appeal. My lord, in the last order, the
Wait.
the order
The
date
petitioner has challenged the order dated 6/10/2023 of the opposite party number 1, passed in revision case number 7 of 1984, in which the opposite party has set aside, opposite party number 1 has set aside the lease granted by the Tahsildar Bhubaneswar in Westland lease case number 515 of 1970 to Hrishikesh Behra.
Hrishikesh Singh.
Hrishikesh Singh? Acha, Hrishikesh Singh. Hrishikesh Behra लिखा है जी, ऑपरेटिव पार्ट रे
it's page 74 here mentioned correctly.
अच्छा ऋषिकेश सिंह लिख दूं on the ground that being a government servant and resident of other district, the original lessee was not eligible for settlement of the land and obtained the lease by suppressing the fact, leading to fraud. And further holding that the revisional authority was right in passing the order dated 27/8/2011 in revision case number 7 of 1984. The Land Counsel for the petitioners submitted that the impugned order is not sustainable in the eye of law on the grounds taken in the writ petition in paragraph number 24. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Let 2 extra copies of the writ petition be served on the Land Council for the state. Matter be placed after 4 weeks, counter, if any, be filed in the meantime. IA number so and so is an application for stay of operation of the order so and so passed by the so and so. Till next date, the operation of the order dated remains stayed. Yes. What is this matter, Mr. Jena?
Lordship, land acquisition matter, Lordship.
Yes.
Notice under Annex 2, page 11 issued to me because we have the landlord as per Annex 1 LS. So we appeared, but it could not be settled since the land has been recorded as a markotdar. It is a private deity, Lordship. If a similar acquisition, Lordship, we can be possible.
Private deity?
Yes, my lord, the private deity.
No, have you got a declaration under 41?
No, this is not there,
Endowment? Then
this is not there. Therefore, Lordship, I had earlier a petition file. It was direction to me to approach before the endowment commission. Their commission will decide whether it is a private deity or not, and accordingly, order has been passed.
Is another order was passed
Yes,
similar?
yes, I've given the copy. Similar order is passed in the other sense, Lordship. He only remanded to the given observation to approach before the endowment commission, and the endowment will decide whether it is private duty or not. Thereafter, the matter can be settled so far the compensation part is concerned.
लाइटर देखिए कि नहीं ऑर्डर तो लिखी दे है ना नहीं
Obligers.
My lord, I was mentioning
Item 33. It may not.
Stay of right.
Hmm?
Stay of relation of file. Where has been granted stay?
Yes.
No.
Okay.
Weekly list item number 24.
Ma'am, please, ma'am. Last occasion, this honorable court directed to furnish copy all the evidence. I have some file for the deposition copy. I have already filed, ma'am. This goes only direct the direction to the last
No,
occasion.
that last order is dated 15/7/2024.
My lord.
That was on a different ground. You filed an application on the ground that the petitioner was a juvenile as on the
My
date
lord.
of occurrence.
At the time of occurrence.
Right. And you relied upon that school transfer certificate, Aadhaar card,
lord.
all these things.
My lord.
So, and also a decision of the Honorable Supreme Court in BJ Singh versus State of Delhi.
My lord.
So, the State Council was provided with a copy of the interim
I have
application.
already.
All right. And the annexure citations to be served. Now, objection is to be filed.
My lord.
They have filed the objection. Uh-huh. Why you are filing this, Mr. President? You are to file objection to the interim application, not the instruction which has been received by you. It is addressed to Advocate General. On that basis, you are to prepare that interim application. An interim application has been filed on the ground that the petitioner is a juvenile,
My lord.
as on the date of occurrence. Okay.
One school leaving certificate which was filed by the petitioner counsel, my lord. On that regard, my lord, I have filed the instruction, my lord.
Whatever you want to do, you have to file an objection to the interim application. You may support the stand taken
My lord.
by the petitioner, or you may oppose this. And you may say that no, this transfer certificate is not correct, whatever it may be. But this is a letter which is addressed by the IIC of Talcher Police Station to Advocate General.
No, my lord. Affidavit is with me, sorry, my lord.
You have mentioned so many annexures, but you have
On
not given it.
27/6/2024, one affidavit already filed, minor.
कौन केबे फाइल कले?
On 27/6/2024.
It's a most peculiar thing. Have you not gone through the order dated 15/7/24?
My lord.
The order has been passed that you are to file an objection, if any,
My
to the
lord.
interim application IA number 2788 of 23.
My lord.
Have you filed that objection?
My lord.
Where is that objection?
On 27/6/2024, I have already filed, my lord.
Have you given a copy to the counsel for the petitioner?
No.
So he has not no right to go through the same. And it's a division bench matter. Why have you filed only one copy?
Sorry, my lord, one copy is with me. Another copy I will file. Okay. And so also the affidavit copy also sought to the applicant counsel.
Have you got that copy?
No, my lord.
अरे objection टा जो दिले बर्तन अपन copy दिए ही ना दी.
नहीं.
Just now, sir.
Got the copy?
My lord.
Come to the paragraphs. Come to page number 4. No. Has he not given all the annexures to him? You provide him all the annexures. What is this going on?
No objection.
Why are you not preparing it in the day before? What is the total number of pages you have received?
Five number of pages. Annexures.
What is the total number?
No, including 24.
It starts from page 26.
My lord.
Annexure page number is 6.
6, my lord.
Acha. Now you come to page number 4.
Page number 4, my lord.
Roman 3. पढ़न्तु कौन लिखा है?
Page number 4, para
3. Roman 3.
My lord. The headmaster of
Mic टा गुटी adjust करी पढ़न्तु. Process सुनिबे.
The headmaster of Kottampua Primary School has submitted in written under his seal and signature that no such student, namely Sanatana Hansa, 19 years, son of Sojan Hansa at Kukuda Munda, hunting PS number Talcher, district Honorable, was studying in Kukutampu Primary School, and no such transfer certificate had been issued in his favor. Original copy written submission in his annexure within annexure 3. Annexure email. I have received the
ट्रांसफर सर्टिफिकेट
कौन बुझिले कौन बुझिले ता माने कौन होची
ट्रांसफर
ट्रांसफर सर्टिफिकेट को आपण अनेक्स करिसेंदी हेडमास्टर कहउचंदी एभलिया कोनोसी पिला आम स्कूल ले पढु नथिले एई जो एमतिया ट्रांसफर सर्टिफिकेट आम स्कूल इशू हेई नाही ता माने इट इज ए फोर्स डॉक्यूमेंट you are filing before the court.
No, my lord.
Claim
the accused.
It would be a serious thing. Just take instruction from your client. Will not leave this man for filing false affidavit to claim juvenile as a juvenile.
Okay,
The consequence of it will be very fatal if you please go through it and whatever he wants to say it. These documents on which you are relying upon to claim that the petitioner was a juvenile as on the date of occurrence is found to be a forged document. This petitioner or the appellant Sanatan Hessa was never a student of that particular school, and this transfer certificate has also not been issued by the headmaster. That is the report, and that is annexed, and the averment has been taken. So,
my lord, according to police report, kindly say, my lord.
We are not on that. If you want to argue, then argue, otherwise you will face the consequence. Please go through it, ask your client.
Okay, my lord.
Because you know what would be the consequence. If the document is found to be forged as per the report or affidavit which has been submitted, then he has to face the consequence also.
Okay,
right? Lekhon. IN number. Order ta jo pass itla dekham. IN number 2788 of 2023. In pursuance of the order dated so and so, the Land Council for the state has filed objection Copy of the objection has been served on the Land Council for the petitioner who seeks some time to go through the same. Put up this matter in the week commencing from 12th August 2024. This objection is taken on record.
Item number 25.
Who has shown affidavit to this interim application?
Well,
who has shown affidavit to this interim application? Interim application re affidavit kiye karichi?
One clerk.
Now what will be its consequence? Your clerk will face.
I verified the.
All right. All. Yes, next.
May I please? The appellant petitioner filed an IA 1275 of 2024 for interim bail as his wife is suffering and therefore for requirement of treatment he wants to release. My lord, the petitioner is in custody.
Wait. You have filed an interim IA for interim bail.
My lord.
On what ground?
My lord, my wife.
Okay. What is your instruction, Mrs. Sahoo?
Regarding interim instruction, no such order passed before this honorable court. regarding
First time it is coming.
My lord.
All right. IA number 1275 of 2024. This is an application for interim bail on the ground of ailment of the wife of the petitioner. mm, have you annexed any medical documents?
Yes, my lord.
Medical documents have been annexed to the interim.
Cerebrovascular accident
The
admitted in hospital.
Learned counsel for the state who has received the copy of the application seeks some time to obtain instruction. Put up this matter in the week commencing from 12th of August 2024. Yes.
Only IA copy be, sir, my lord. Medical document not attached here.
Annexure 1 and
Just
2.
now.
The
Annexure 1 time.
The Learned counsel for the state submits that only interim application has been served, but not the annexures. The
Just now I
Learned
am
counsel
serving, my lord.
give it the catigan, sir. Yes, next.
Item number 26.
Yes, Mr. Saugat Das. I'm more than yes, but. Yeah, give a call to Mr. Das, Saugat Das. Yes, next matter.
Item 27.
Well, last occasion, Madam Director to submit the details of the antecedent corresponding to PS case number Gopalpur PS case number 72 of 2010. In this case, Madam, I am submitting the certified copy of the order which has been disposed of on acquittal in favor of the appellant, Madam. Copy.
Only one criminal antecedent was there.
Yes, yes, madam.
You have been acquitted.
Yes, madam.
देखिए कौन?
On 8/8/2017, it was disposed of.
Judgment copy টা দিয়েছেন দি?
Madam.
Gopalpur PS case number 72 heart page. Natahala Sankar.
Or at the end of the judgment.
All right. Now, what do you want?
No, I'm paying for bail, my lord, for the 13 years he is remaining custody.
Custody since 13 years.
Madam. 28/10/2011 since he is in custody.
What is the allegation against you? What you have done? It's a case under 302.
Madam.
So, what is the prosecution case?
Prosecution case.
Whether this is your first bail application or earlier rejected?
Yes, first bail application.
First bail application.
He never applied before this.
Okay, please come to paragraph number 2 of the impugned judgment.
Judgment, madam.
To know the prosecution case.
Madam.
Paragraph 2.
This one. Prosecution case.
एक mic adjust करो.
Are the as follows. On 7/10/2011.
27/10.
Madam, sorry, madam. On 27/10/2011, around 12 noon. This is around. This is along with PW 8, who happens to be the brother-in-law of deceased, proceeded to Barampur in a motorcycle for repairing of motorcycle. Arriving at Barampur, they went to Harapriya Hotel to meet the friend of the deceased, as the deceased was working there earlier. While passing through the old bus stand for the purpose to arrive in village Lathi to their uncle's house, on the way near Jagabandhu Sahi, the accused Shankar Naik and accused Shiva Mahapatra, coming in a motorcycle from their front side, restrained them. It is said that accused Shankar was a pillion rider, whereas accused Shiva Mahapatra was riding a motorcycle. Accused Shankar brought out the pistol and fired the deceased on his chest. As a result, the deceased succumbed to injuries at the spot. It was around 10:30 p.m. The occurrence took place. PW8, out of fear, left the place and returned to village Saulai, where he informed the informant, the spouse of the deceased, and others as to death of the deceased by gunshot injury, having fired through a pistol by accused Shankar and his companion accused persons. It is said that owing to quarrel arose in between the deceased and accused Shankar, Ranjan and Shiva Mahapatra, prior to the occurrence, having they threatened the deceased to do away with his life, the informant and deceased, out of fear, went to Surat and prior to 1 month of the occurrence, returned to their village to solemnize the birthday of their son. This is the para 2 of the judgment, madam.
So the eyewitness is obviously that man.
PW8, madam.
PW8.
Right.
And he has stated in the line of what has been mentioned that you are that man who fired gunshot at the deceased.
PW8, madam.
Supported the prosecution case, madam. Supported the prosecution case, madam, on para 2, madam.
Motorcycle was driven by Shiva Mahapatra. Shankar was sitting. Okay, thereafter Shankar and Suresh have separated them since both of them, I do not know, registered Shankar also. They Dhanna and brought out a pistol from the backside, fired Suresh by means of that he chased.
Para 2, the specific allegation. In para 2, my lord, specific allegation against the present petitioner, madam.
Yes, sir. That is also elaborately stated in paragraph number 6. Brought out the pistol and
My lord.
Para 6. Para
and doctor's evidence is
161 रे सब 13 part टा नहीं 161 रे 13 part टा जोटा para 5 रे कौन सी
short part अछि ना नहीं सेटा होची मेन ना 13.
PW8.
What is the who is the doctor?
Dr. PW9, my lord. No such weapons of offense has been seized, my lord, or produced before the court during trial, my lord.
So the doctor has noticed injuries and his opinion consistent with the entry wound, so and so. Deceased as a result of time since death. Possible from gunshot injury from the short distance. So your how many days you have been able to learning?
My lord, 28/10/2011. Occurrence took place on 27/10 and next day he was arrested, my lord.
28/10/2011.
My lord.
Shankar on 3 forward agent. Produced in custody. IA number 1466 of 2024, there is an application for bail. As per the order, last order, as per the order dated 24/7/2024, the Land and Council for the petitioner has filed the judgment passed by the Land and Assistant Session Judge cum CGM Ganjam Barampur dated for the 8/8/2017 in Sessions Trial number 68 of 2012, which shows that the petitioner faced trial along with one K. Duryodhan Reddy and has been acquitted of all the charges. The judgment is taken on record. The Land and Council for the petitioner submitted that the petitioner is in judicial custody since 29/10/2011 and paper book has not been prepared and therefore there is no chance of early hearing of the appeal in the near future. He further submits that the case, the conviction of the petitioner is mainly based on the evidence of on the evidence of PW8 Jogendra Patra, who is an eyewitness to the occurrence and stated to have seen the appellant firing gunshot at the deceased Suresh Patra. Land Council further submits that there are good chances of success in the case. Balance of convenience is in his favor, and therefore the bail application may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and submitted that the evidence of PW8 is getting corroboration from the evidence or the medical evidence which is adduced by PW9, the doctor who has noticed gunshot injury on the person of the deceased and opined that the cause of death as a result of hemorrhage and shock due to such injury. Considering the submission and further stated that the injuries number 1 and 2 can be possible by gunshot from a short distance. Considering the submission made by the Land Council for the respective parties, nature of overtact attributed against the petitioner as per the evidence of the eyewitness, so also the medical evidence, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody, we are inclined to release the petitioner on interim bail for a period of 1 month. And during that period, he will appear before the Kuthana, appear before
Gopalpur PS.
Gopalpur Police Station once in a week on every Sunday in between 10 to 4 and shall not indulge in any criminal activities and shall not try to come in contact with the family members of the deceased. Violation of any terms and conditions shall entail cancellation of bail. A report be called for from the IIC of Gopalpur Police Station relating to the conduct of the petition. Okay, yes, next.
1 month, my lord.
1 month we'll see your conduct, then we'll consider. Yes.
Okay.
My lord, I'm sorry, my lord. The matter was.
No, it's all right. You can argue the matter. Item number 26.
May I?
Yes.
26, my lord, last occasion lordship directed to regarding the obtain instruction regarding the criminal antecedent, my lord. Kindly this matter may be taken up day after tomorrow, my lord. I have already sent the letter.
Yes, that was the order passed on 15/7/24.
7, my lord. I have already sent, my lord.
So you want us to take this matter from the weekly list day after tomorrow?
My lord. Monday.
Monday? Yes. All right. The Land Council IA number 56 of 2020. The Land Council for the state submitted that instruction has already been sought for to collect the criminal antecedents, if any, against the petitioner, and matter may be taken off next week. As prayed for this matter, we commencing from 5th August 2024. Yes.
Item number 28.
Mr. Saugadas, Land Council for the is present. Yes.
Last occasion, your lordship has directed the state to provide me a wakalat. That
No, she sign korikin debe. Original ta sign kor diyo, eta kon do. Original ta she sign kor diyo. That number is not mentioned. His mobile number mentioned kor diyo.
मैं करके दे दो छे मंडल लिस्ट तो
Mobile number ta likhi diyo. Tale apno na ta likhai chi we namare. Mobile number ta likhai na as per the you have to mention it. You want to argue this bail application on Monday? All right. As for the order dated so and so, the Land Council for the state has produced the wakalatnama executed by the appellant and handed over the same to Mr. S.K.Sahoo in court. He filled it up and filed. The same is taken on record. Mr. Sahoo seeks for an adjournment till Monday. Court of this matter we commencing from 5th August 2024. The name of Chittaranjan Sahu shall not be reflected in the cause list henceforth. Yes.
Item number 29.
Mr. Raut.
May I please read? And last occasion on 16/7/24 millet, the criminal antecedent and the costly certificate was called for millet.
I have already obtained, my lord.
What is the period of custody? Three, 4, 6, 8, 9 years, 7 months, 18 days. Okay. And what about the criminal antecedent?
Two criminal antecedents.
Two cases are there. 392, 394, 307/34. So what is the status of these two cases, Mr. Rautrai?
I have no instruction. I will
Get the instruction. All right. As per the order dated so and so, the Land Council for the state has produced the custody certificate from Superintendent District Jail Jharsuguda, which is taken on record. He has also filed written instruction received from IIC Orient Police Station Jharsuguda relating to the criminal antecedents against the petitioner, who show that the petitioner has got two criminal antecedents. The Land Council for the petitioner seeks some time to obtain instruction about the status of those two cases and file a comprehensive affidavit to that effect. Put up this matter. 12 Tarik Rasu? Place this matter in the week commencing from 12th August 2024. This is taken on record for that.
I received the instruction from the state council.
The copy, the name, the case numbers have been supplied to the Land Council for the petition. Yes.
Item number 30.
May the Lordship. Offense under section 302/34 IPC. The co-accused has been released on bail. He is inside custody since 17/1/2014.
Just a minute. This CRLA 795/2022. Sole appellant.
My lord.
Bharati
Conta.
Conta. So, what are the offenses under which you have been found guilty?
302/34, my lord. Only a wire was seized from.
302.
Strangulation.
Strangulation, lordship.
What is the name of the deceased?
Prahlad Kanta.
Prahlad Kanta. And date of occurrence is 15/1/2014.
14, lordship.
You are related to that deceased.
My lord, I am the wife. I happen to be the wife.
So, prosecution case is that you, along with your husband and a minor son, namely Prince,
My lord.
who was aged about 2 years, you are staying together in a quarter of the Hall Sunavada, right? And your husband was found dead inside that quarter.
Quarter.
And it was a case of strangulation by means of a wire.
Wire.
Right?
My lord.
Electric wire was seized. Acha. Then what is your explanation? Obviously, there would be no direct evidence. This case is based on circumstantial evidence, right? So, are you disputing your presence inside the house at the relevant time? In your accused statement, ନା ମିଛ କଥା ଖାଲି କହିଛନ୍ତି ସବୁ ଗୁଡାକ ନା ମୁଁ ଗରିବ ଘରର ଝିଅ ମୋ ସ୍ୱାମୀ ତାଙ୍କ ବାପା ମାଙ୍କ ଇଚ୍ଛା ବିରୁଦ୍ଧରେ ମୋତେ ବାହା ହୋଇଥିଲେ ମୋତେ କେହି ପସନ୍ଦ କରୁନଥିଲେ ତେଣୁ ମୋ ସ୍ୱାମୀ ମୋତେ ଅଲଗା ରଖିଥିଲେ ଶାଶୁ ନଣନ୍ଦ ମୋତେ ଆମ ଘରକୁ ଆସି ପିଟୁଥିଲେ that is not nothing. So, who is the doctor who conducted PM?
PW1, my lord.
PW1.
Right. Thank you.
One ligature mark almost encircling the neck, present horizontally with length of 32 cm, width is 1 cm. Another ligature, internal examination, it is found that so and so is a surgery. All the injuries are antemortem. Cause of death is due to asphyxia resulting from strangulation. ସେ ଛୁଆଟା କୁଆଡେ ଗଲା କାହା ପାଖରେ
with my mother.
ଆପଣଙ୍କର ଇଏ ହେଇଗଲା 10 ବର୍ଷ ହେଇଗଲା. You have not been released on bail during that.
This is my certificate also, lordship, that I have a good report since last.
Mrs. Sahoo, why is there any kind of motive attributed? They were staying separately from the in-laws family members as it appears, and husband perhaps was an employee of the hall.
Driver.
So,
Driver, you were driver.
Driver. So, why the petitioner killed her husband? Anything is borne out from the record to that effect?
As per the prosecution allegation, my lord, always they both are quarrel to each other, my lord.
Kono?
As per the prosecution allegation, my lord, both were quarrel to each other, my lord.
Okay. No, they were blessed with a son that is 2 years. So
Have a glance on the statement of PW8, my lord, who is the last seen in this case, my lord. The name of the son of Prahlad Prince on the para 2, my lord, on the last line, my lord.
Yeah. Para 2?
Para 2 on last.
The name of the son of Prahlad.
My lord, is Prince. After taking food while we are coming down for through staircase at that time, accused Bharati abused deceased Prahlad and also told that the deceased has caused her life hellish. My lord. In return, Prahlada told to Bharati that as to why she was abusing against him in presence of his friends. At this, accused Bharati being infuriated gave threatening to Prahlada that
ता पूर्व टिके पढ़िले जो पैराग्राफ 2 आरंभ एटा जो मकर संक्रांति दिन घटनाटा हिची.
my lord.
So deceased Prahlada was my friend. Prahlada had asked me and so and so to his house for Makar festival to give us food.
My lord.
He had asked to so and so. According to we three went to this quarter, gave us biryani. Then we played with the so and so, name of the son or son. After taking Racha, then what happened? Bharati being so and so was threatening on that his last night she would ask for whatever he would like to do. As it was a family dispute between this so and so. Acha. মানে ঘরোই কলি হঠাৎ ହେଇକି নি are the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submitted that the petitioner was taken into judicial custody on 18/1/2014 and she is the wife of the deceased judgment article Prahlad Kanta and the occurrence in question took place on 15/1/2014 night. Case is based on circumstantial evidence and there is no clinching evidence on record and regarding the commission of the crime by the appellant, and there is also no motive on the part of established by the prosecution, the part of the appellant to commit the crime. It is further argued that there are good chances of success in the appeal and the 2-year son of the petitioner. The petitioner and deceased son was 2 years at the time of occurrence and she is now residing with the mother of the petitioner. And therefore, the bail application may be favorably considered. Learned Counsel for the state placed the evidence of the doctor bracket PW1 was stated to have noticed ligature marks encircling the neck of the deceased and opined that the cause of death was due to asphyxia as a result of antemortem strangulation. Considering the submission made by the Learned Counsel for the respective parties, the nature of evidence adduced during trial, the period of detention of the petitioner in judicial custody, absence of any chance of early hearing, and since the petitioner is a lady, we are inclined to release the petitioner on bail allowed.
Item number 31.
Mr. Panigrahi.
May I
Yes.
please, my lord?
Yes,
Criminal
yeah,
antecedent was called for, my lord.
Huh?
Criminal antecedent was called for.
Asila.
My lord.
अच्छी किसी
No criminal accident.
file करूँ so you are in custody since when?
My lord. 1/4/2016 my lord.
1/4/2016 and you have been found guilty under section
302.
302 and come to the paragraph number 2 of the judgment. Let us know the prosecution case.
Yes. The accused arrived when the deceased was sitting on the veranda of his house. The accused arrived there being armed with a tangia and assaulted to different parts of his body, causing his death. It is also alleged that the accused assaulted the deceased Gurujani by means of an axe, suspecting that he was practicing witchcraft upon his son Somanath Jani. This is the allegation. The deceased were practicing witchcraft upon the son of a
Eyewitnesses are there.
eyewitness.
Who are the
The
eyewitnesses?
daughter of a deceased my lord.
PW?
PW 12. Minika Jani.
Daughter of deceased.
Yes, madam.
And who is the doctor who conducted PM?
PW 8.
PW 8, my lord.
So what PW 12 has stated? Eyewitness? The accused Samarjani arrived there, assaulted my father by means of an axe, causing bleeding injury on his head, face, neck, chest, and back.
etc. by the
On एक थोड़ा मत अच्छा so who is the doctor? PW 8.
PW 8.
How many blows you have given? Incised wound
Multiple.
passed on this one, so then incised wound 2 in number, incised wound on the neck, left eyebrow, then left clavicle, so ପାଞ୍ଚଟା ଖଣ୍ଡେ ବ୍ଲୋ ସବୁ ମୁଣ୍ଡରେ ମାଡ଼ ହେଇଛି।
Cause of death, head injury, spinal cord injuries.
8 ବର୍ଷ ହେଲା। Are the learned counsel for the petitioner, learned counsel for the state, learned counsel for the petitioner submit that the petitioner is in judicial custody since 1/4/2016 and as such he has remained in custody for more than 8 years. He further submits that as for the eyewitness account of PW 12, the daughter of deceased, Gurujani, petitioner assaulted the deceased by means of an axe and since the appeal is of the year 2022, there is no chance of early hearing of the appeal. The bail application may be favorably considered. As per the order dated so the learned counsel for the state has obtained written instruction from IIC of Puthur Thana, IIC,
Koraput Sadar, my lord.
Koraput Sadar Police Station, that there is no criminal antecedent against the petitioner and the same is taken on record. The Learned Counsel for the state, however, submitted that the evidence of the eyewitness PW12 is getting corroboration from the evidence of the doctor PW8 who conducted post-mortem examination and noticed as many as 5 incised wounds on the vital part of the body like head, and the cause of death has been opined to be polytrauma like the head injury, spinal cord injury, open fracture, left clavicle and multiple wounds and its complication thereof. Considering the submission made by the Learned Counsel for the respective parties, the nature and gravity, the nature of evidence adduced by the prosecution, particularly through the eyewitness PW12. So also the post-mortem report findings, which is proved by PW8, while not inclining to release the petitioner on bail, but taking into account the period of detention in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on interim bail for a period of 3 months. While on interim bail, the petitioner shall not indulge in any criminal activity and shall not try to come in contact with the family members of the deceased. Violation of any terms and conditions shall entail cancellation of bail. Fix the day case to 3 months after. Yes.
Item number 32.
My Lord, item number 32, on behalf of Mr. Udit Ranjan Jana, today I am serving the deposition copy. Kindly adjourn this matter
Next week.
Yes, my Lord.
The Learned Counsel for the appellant served the deposition copies to the Learned Counsel for the state in court today, who seeks some time to go through the same. Learned Counsel for the appellant also seeks for an adjournment. List this matter in the week commencing from 5th August 2024.
Oh, yes, sir.
Item number 33.
May I please, Lords? Yeah.
33 also just now serve the deposition copy, my Lord.
Deposition copy.
My Lord.
Same order for the 5/8/2024. Yes.
Lord's call for any antecedent of the appellant.
Agur Mokaino? Yeah. Acha. Learned Counsel for the state seeks some time to go through this one and also obtain instructions about the criminal antecedent if entered at bar. Yes, next.
Item number 34.
Mr. Biswaranjan Dalai. Not there. House empty Passover again.
Item 35.
Appellant. Let me collect the deposition copy. Let it be taken up tomorrow. There to
देखी कौन 8 साइन देखी आर्गुमेंट करियो ना
tomorrow.
हाँ काली की रहेगा ठीक है. Yes. काली की देखी.
Item number 36.
Mr. Pushpamitra Mahapatra. Yes. Next.
Item number 37.
Was appointed. Petitioner's petition has been filed. Acha. Engagement of Mr. Biswajit Thankra prayer engaged. Also filed Vinama. ठीक है. You will file the application for condonation of delay. 1/7/2009 टाइम लेकिन चल रही Who is the learned counsel?
Item 37, my lord.
Biswajit Tripathi.
Yes, yesterday he was sitting. କାଲି ଥିଲେ ମୁଁ ଦେଖିଲି।
ଟିକେ କୁହନ୍ତୁ ତାଙ୍କୁ ଦେଖିବା।
I
ଏ ଆଇଏଟା ଫାଇଲ କରିଥିଲେ କରିବେ ବୋଲି କହିଥିଲେ condoning the delay 66 days delay is there ତାଙ୍କୁ କହିଦେବେ ତାଙ୍କୁ
କାଲି
ହଁ ନାଇଁ we are adjourning ମାନେ adjourning ମାନେ କିଛି ଅର୍ଡର ପାସ୍ କରୁନୁ କାଲିକି ଡକା ହବ ହେଲା yes next
Item number 38.
Last occasion, my lord, for the criminal antecedent in
custody certificate and criminal antecedent ଦିଟା ଜିନିଷ ପାଇଁ ଥିଲା। ଆଠ ବର୍ଷ 5 ମାସ 21 ଦିନ no criminal antecedent acha yes argue the matter
actually today I got the paperwork by that's any day next week
you want it next week
yes
all right the learned counsel for the state has produced the custody certificate so also instruction regarding the criminal antecedent received from IIC Bidanasi police station, which are taken on record. The learned counsel for the appellant submits that he has received the paperwork today and the matter may be taken off next week as prayed for. List this matter we commencing from 5/8/2024. Yes.
Item 39.
May please, your lordship, on behalf of Mr. Sivanaran Vishwa, kindly taken up any day this week.
Next week.
This week, next day. Today, he is not able to submit before your lordship.
You are mentioning on behalf of Sivanaran Vishwa.
Yes, madam.
So who is
Not
appearing for KIT University?
Appearing for kid. It's not.
What is the CMAPL?
Lordship, the CMFL is about a writ appeal has been filed by the appellant, Makanta Samanthi, Lordship.
Okay.
The writ appeal has been dismissed because the client, the counsel was not there in
Not
the.
there.
Yes,
For
your lordship.
restoration.
Yes, your lordship.
Okay.
Lordship, not today, any tomorrow or day after tomorrow.
No, it is up to you. You have to tell we are there for entire week. This list is there.
Yes, madam.
If
Tomorrow.
you want it tomorrow, it can be
Tomorrow.
taken off. If you want next week, it can be taken off
Tomorrow.
tomorrow. All right. Mark it off a date they can tell you. Yes.
Obliged.
Item 40.
Mr. Misra.
My lord, CMAPL for restoration, my lord.
There is a delay.
My lord.
336 days.
My lord.
You have filed an interim application for condonation of delay.
My lord, my lord.
Notice has been issued.
No, my lord.
Okay.
The CDA is party, my lord.
Who is the
If my lordship will direct, I will
CDA?
serve a copy on Mr. Mahapatra, my lord.
No, CDA is the only party.
Only party, my lord.
So watch out. Okay. Dayanand Mahapatra.
Yes, yes.
All right.
I will serve him a copy, my lord.
IA number 248 of 2023. There is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 336 days in filing the CMAPL. Since Mr. Dayanand Mahapatra used to appear for all the opposite party, let the Land Council for the petitioner supply copy of the
My
interim.
lord, Mr. Mahapatra has received copy on 21/8/2023. This is the receipt.
21/8/23.
Yes, Mr. Mahapatra has received copy.
Not out in
CMAPL petition along with
The IA.
The Learned Counsel for the just short the copy now the Learned Counsel for the petitioner submits that he has already served the copy of the CMAPL, so also the IA on Mr. Dayanand Mahapatra, advocate who used to appear for the opposite parties. The matter be listed next week, that is we commencing from 5th of August 2024, indicating the name of Mr. Dayanand Mahapatra in the cause list. Yes.
Yes.
Item 41.
And on behalf of Mr. L. Misra, I'm praying for next week.
Interim application for bail and state relation of fine. All right, CRLA number so and so, a mention is made on behalf of Mr. Lalithendu Misra for adjournment next week.
Yes, ma'am.
Till next week, please this matter, we commencing from 5th August 2024.
Item 42.
This is the lordship last decision and carried with the Learned Counsel for the state to obtain instruction as to whether they have prepared any appeal or not. Because there are 5 persons who have been murdered.
So and so 5 persons. Learned Counsel, he intends to obtain instruction as to whether there is any proposal from the side of the state to challenge the sentence of life imprisonment or not. Raise this matter in the week commencing from so and so.
No instruction received next week.
ଆପଣ see that 5 murders have been committed. The Learned Counsel for the छोटो छोटो केस गुड़ा कर अपन अपील फाइल कर दे रिवीजन फाइल कर दे अपन 5टा मर्डर हेची, they have been found guilty and yes,
32 जन accused, 20 were being convicted, 10 were absconder and 2 were juvenile. Appeal
32.
Yes, my lord. 32 accused, 20 were convicted, 10 were absconder.
No, whether you are, it's a case of life imprisonment.
My lord.
So whether you have filed any appeal challenging that, that is the instruction we just want to know.
My lord, I have to.
So, look on, Learned Counsel for the state seeks some further time to obtain instructions as to whether there is any proposal with the government to challenge the sentence of life imprisonment awarded by the Learned Trial Court to the accused persons for commission of murder of 5 deceased. This matter. Okay, next week though?
Next week, man. 19 तारीख चिट्ठीटा जाइते
commencing from 5th August 2024. Yes.
That I have.
The Learned Counsel for the state submits that he has already received the deposition copy supplied by the Learned Counsel for the appellant. Yes. Yeah, this matter along with our number would have actually master matter. Next page, question. Yes.
Item 43.
Mr. Durga Prasanna Misra. Next.
Item 44.
44, Miss.
May I please your lordship?
Your matter.
The sole appellant may not convicted under section 302
IPC
IPC and the occurrence in custody since 22/2015.
You have got the deposition copies
Yes.
with you?
I have already saw.
Okay. So, 44, it is CRLA 644 of 2024. And it is a sole appellant,
Yes, my lord, sole appellant.
Santosh Khadia.
Khadia. Entire prosecution case.
What is the date of custody?
Date of custody, my lord, 22/2015.
22/2.
22/2015. My lord.
Okay. So, who is the deceased?
Vasudev Khadia.
Vasudev Khadia, the father
Vasudev
of
Khadia.
PW1.
Acha.
Father of PW1.
Is there any eyewitness to the affair?
Yes,
Two
my lord.
person are there.
PW1,
PW1 is the
Two,
eyewitness.
six.
son of the deceased. My lord.
Son of
PW2 and 6 also the eyewitness.
Huh?
PW2 and 6 are also eyewitness.
अच्छा PW2 and PW6 अच्छा गोटे एविडेंस को आसीबा PW1 को देखिबा
Yes, my lord.
हां
My lord, PW, I am coming to the evidence of PW1.
yes we are
Yes, I am the informant. The accused is of my village on 19/2/2015 in the evening while my father was bringing a pair of bullock. Both the bullock went towards the house of the accused. As it became late, I went to search my father and I saw that while my father was bringing back the bullocks, the accused came out from the house and started dealing wooden plank blows on the person of my father. Out of fear, I rushed to my house and informed it to my mother. Thereafter, both myself and my mother went to the spot, and some villagers also gathered there. As my father had sustained bleeding injuries, I immediately took him to Burla Hospital.
so it is by means of wooden plank that you have assaulted the deceased. Who is the doctor?
PW13.
PW13 is the PM doctor, my lord.
PW13 lacerated wound on the
Left
leg
leg.
one fracture left tibia 3 abrasion chanantu abrasion palm 3 parallel contusions on the middle of the back of the left side of the scapula. Acha.
My humble submission is that, my lord, PW10 is also the wife of the PW1. PW10 is the wife of PW1, my lord. She stated that PW1 was not at this spot and has not seen the occurrence. And hearing from the villagers, they came to the spot along with her husband, PW10, my lord. And we see the evidence of PW10, my lord. The informant is my husband. Deceased is my father-in-law. On 19/2/2015, in the evening, the accused, who is of my village, assaulted my father-in-law by means of a wooden plank in front of his house. My father-in-law sustained fracture in his leg and felt senseless. Hearing about it from the villagers, I, along with my mother-in-law, and my husband went to the spot, gave some water to my father-in-law, and thereafter carried him to my house, and wherefrom he was taken to Burla Hospital, where he declared dead. Admittedly, there was a land dispute also between the parties, my lord, and there is the contradiction that the presence of PW1 at the spot and seeing the occurrence is doubtful, my lord.
They are related to each other. FIR
villagers, co-villagers.
No. Please, FIR କହୁଛି ମୋର ମାମୁଁ ସନ୍ତୋଷ ଘଡିଆ କେଡିଆ ନା ଗଡିଆ ମୋର ବାପାଙ୍କୁ ମାଡ ଦେଲେ ତା ଗୋଡ ଭାଙ୍ଗି ଯାଇଛି. Informant is the
Kalakanu Khadia is PW1, na?
PW1,
So he has stated in the FIR that
Exhibit 1.
ସେଇ ସମୟରେ ମୋର ମାମୁଁ ସନ୍ତୋଷ କଡିଆ is the appellant. ହଠାତ୍ ଗୋଟିଏ ବାଡିରେ ମୋର ବାପାଙ୍କୁ ମାଡ ମାରିବାରୁ ତାଙ୍କ ବାମ ଗୋଡ ଭାଙ୍ଗି ଯାଇଛି।
ଗୋଡ ଭାଙ୍ଗି ଯାଇଛି।
ହଁ, ଆମେ ଖବର ପାଇ ସନ୍ତୋଷ କଡିଆ ଘର ପାଖକୁ ଯାଇ ଦେଖିଲୁ ମୋର ବାପା ତଳେ ପଡିଯାଇଛି, ତାକୁ ସାଙ୍ଗେ ସାଙ୍ଗେ is right that wife is telling correctly.
So far PW2 and 6 man they are
But so far as PW1 is concerned, he is a post occurrence witness. 2 and 3 कौन कहुଛନ୍ତି?
that informant is my brother-in-law. This is Vasudev is my father-in-law. I know the accused who is of my village. One day in the year 2015 in the evening, while I was returning from work, I saw the accused dealing wooden plank. Blows on the. I saw the accused was dealing wooden plank, blows on the deceased Vasudev. Myself and other thereafter took the deceased to Burla Hospital, but the doctor declared the deceased dead. The informant thereafter lost the.
Prosecution ମନା କରିଛି।
Okay.
Para 3 ରେ। While I was going to take my bath in the evening after
And as it appears, Mr. Tripathi, this injuries were caused on the ribs. This fracture of ribs, 4th, 6th, and 7th, that is the cause of death. It was not the on the head. There is no blows given. That is the thing.
Lacerated wound, fracture of left tibia.
One lacerated injury or
parallel contusion approximately 1 centimeter present in the middle and back of the left side below scapula. Middle one.
ରାସ୍ତାରେ ପଡିଗଲି।
ଏଇ ଜାଗାରେ ସବୁ ମାଡ ହେଇଛି। ସେଇଥିପାଇଁ ଦିଟା dissection ରେ ଦେଖଉଛି ତିନିଟା bone fracture ହେଇଛି ribs.
There are fracture of rib 4th,
6th, and 7th.
On the right side will
other coastal muscles. And that is the cause of death, heart, so on. So. PW1, who is the son of the deceased, posed himself as an eyewitness to the occurrence. But the first information report lodged by him would show that he is a post-occurrence witness. And moreover, PW10, who is the wife of the PW1, has also stated that she, along with her mother-in-law and PW1, came to the spot after getting coming to know about the occurrence from the villagers. The Learned Council further submits that since the criminal appeal is of the year 2024 and there is no chance of early hearing, the bail application of the petitioner may be favorably considered. Learned Council for the state submitted that apart from PW1, PW2 and PW6 are the eyewitnesses to the occurrence, and their evidence regarding assault on the deceased by wooden flank is getting corroboration from the evidence of the doctor, bracketed PW13, who has noticed some injuries on the left leg, left tibia, right palm, and left side below scapula, and opined that there was fracture of ribs 4th, 6th, and 7th on the right side, and the cause of death was due to shock and hemorrhage resulting on account of rupture of the lung and fracture of the long bone. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced during trial, the period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail, stay realization of fine. Yes.
Item 45.
61 days to delay to file the.
You have filed the delay condonation application.
Yes, ma'am.
And here you have been found guilty under section
372A, 376A, and the 302.
376?
A,
376 2I,
2I, and
376A and
302.
302. Life imprisonment. Right.
Life.
Under section 6 box.
Right. IA number 1614 of 2024. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 61 days in filing the criminal appeal since the petitioner has been sentenced to life imprisonment. After hearing the learned counsel for both the parties, we are inclined to condone the delay. Accordingly, delay is condoned, IA is disposed of, hard admit, call for the trial court report. Any applications you have filed, interim application?
Yes, ma'am.
Interim application for
Stay realization of fine.
realization of fine to be considered after receipt of the trial court report. Yes.
Sir, I also filed bail application.
That will be considered after
Yes.
receipt of the. So, anyone is ready in the jail criminal appeal? or-
Kali jail criminal 47 Kaliaram.
Tally kariye.
Kaliaram kariye date of.
47.
Yeah. Susmita.
We will take up tomorrow because the orders matter are almost over. So,
Okay.